What's the offer? Is she Oh, you don't have right. Okay. Sure. Was he on probation?
No, this is his first time.
Okay.
He's only 18.
He is a little guy. He's just a little guy. I love it. Learning.
All right, good morning, everyone. See, there we go. We have a calendar that's labeled Plea calendar with 15 positions, but not 15 individuals. And Ms. Nelson alerted me that a couple of these are possible non-events, but we'll see. Positions 1 and 2 are Mr. Blue. Is that still going forward?
Yes, I just spoke with him yesterday. I want to just button everything up before we bring him out.
And Ms. Smith had to run over to the clerk's office because it was a re-indictment.
Yeah, both were going to be re-indicted.
But she doesn't have the new indictment. She's done it, but she's gone to the clerk's office to clear that up.
Got it. So we'll hold on that. But it was a re-indictment.
Yes.
Okay. Larry Phillips.
In custody judge, we're ready to go. I am expecting a representative of the program that we're putting him into to be here, but we'll be ready as soon as Mr. Benjamin gets here.
Okay. And Mr. Benjamin.
It's a program that.
Oh, this is someone from the program.
Yes.
Got it. Okay. But this is Ms. Smith's case, so we would need her. Okay. Jody Araldo.
She's mine. She should be in custody.
Gosh, she's been in custody for a long time. I don't remember much about this case.
Well, it's because it hasn't even been on arraignment. It
Oh.
was set for July 7th and we're being very proactive.
All right.
I just need to speak with her, but this should be a negotiated.
Okay. And she does not need an interpreter. All right. Tandon Gaddy.
He's mine. He should be here. I will follow up to see where he's at.
Okay.
It's clear.
Got it. And that's you. All right. Willingham. Michael with a Y Williams.
If my right, that'll be a plea and a probation revocation.
Well, he's been in jail even longer. Okay. Aaron Spencer has a couple cases.
Plea.
Something is funky about he's been in jail for 3 years on
He had another case too that was in Judge Hopkins' courtroom.
that move more slowly.
Yeah, it was on a trial counter, and that got resolved, and then he just couldn't make the bond, so that's why he's.
Got it. And so these two remain behind. Okay. Darius Fields.
Plea negotiated, all these are negotiated.
Okay. Chad Johnson, I think has two. No, just one case.
Plea.
Plea also. Calvin Jordan has 3 cases.
He has been. Okay, Judge, we're gonna try to do this one on Monday.
Because there's nothing else going on Monday.
Just, there's all 3 cases and Ms. Smith and I just need one more piece of the puzzle before we can wrap it up.
Okay, including Mr. Jordan. He would be one of the pieces of the puzzle. So the hope is Mr. Jordan can be brought over on Monday. Okay. Then Bryant Woods.
Same situation, that PI case is getting accused and that should be taken care of by Monday.
Okay, so 11 through 14 are to Monday. Does Ms. Nelson know this yet?
Yes.
Okay, And then DeAndre White.
He's mine, he should be here in person, it'll be a negotiated plea.
Yes, sir.
And that's Willingham also. All right. Okay. Are you Mr. Gaddy? He's here. Should we start with that since Ms. Smith isn't here? Is that all right with you, Ms. Willingham?
Yes.
All right.
And Ms. Nelson, I just sent you a proposed order on another piece. Okay, so.
Mr. Gaddy, can you slide right here? Sorry. Thank you.
You're welcome.
How are you today?
I'm doing good. How you doing?
Good, good to see you. Oh, really? Okay. Two keys together. Okay. How many?
3.
Okay, got it.
Let me know when you're ready. No problem.
Make sure I have the facts open too.
Okay.
Okay, so then she's. And make sure that you understand that's what the original charges were, and then she'll tell us what what the reduction is that we talked
Okay.
about. Okay? So no, there's people on, 'cause.
Okay, let's get on the record. This is position 5 from today's calendar, 26 SC 002-071. State versus, pronounce your last name, sir.
Gaddy.
Gaddy, State versus Mr. Gaddy, who is in court with his lawyer, Ms. Wood. Ms. Willingham is handling the case for the state, and Mr. Gaddy, Ms. Wood tells me you're prepared to enter a plea in your case. Is that correct?
Yes.
In just a moment, Ms. Willingham will put you under oath, after which she'll ask you a bunch of questions about you and your case. Please answer those truthfully and completely. Also, let me know, or Ms. Wood, if at any point you have questions or you're not following what's going on. Will you do that?
Okay. Yes.
Great.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand down. Please state your true, correct, and legal name.
Standing Gaddy.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
How old are you and how far have you gone in school?
44. Finished high school, some trade school.
Are you able to read, write, and understand the English language?
Yes.
You understand that you have the right to plead either guilty or not guilty to these charges, and if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your lawyer about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Counsel, Mr. Gaddy, do you need any more time to discuss the case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes.
Counsel, are you satisfied your client has a full understanding of this proceeding?
I am.
Have you reviewed the indictment in this case with him?
We have.
And do you waive formal reading of the indictment?
So waived.
Has your client been arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Do you or your attorney or your client know of any outstanding warrants related to these charges?
We do not.
Mr. Gaddy, do you understand that the state has agreed to reduce each count of this indictment? Count 1 will be reduced to battery family violence. Ms. Nelson, I will provide you with the code sections by email. Count 2 will be reduced to criminal trespass. And each of those counts will have a 12-month probation. And those counts are to run consecutive or one after the other for a total of 24 months probation.
Yes.
And the special conditions would be to have no violent contact with the victim, complete family violence intervention program, complete 60 hours of community service, seek and maintain gainful employment.
Yes.
Is this what was explained to you by your attorney?
Yes, ma'am.
And do you understand that the court does not have to accept that recommendation? And the
Yes.
court can sentence you to the maximum sentence on each charge and can run those sentences consecutively or one after the other, which in this case would be 24 months in custody.
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes.
Are you on probation or parole for anything anywhere?
Yes.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
One moment.
I had an altercation with my son.
Is it
ABM,
in Fulton County?
yes.
Is it a misdemeanor?
Yes.
Okay. And when does that expire?
As soon as I pay the fines off.
Okay. So
It's
basically,
like a year, but the sooner I pay it off.
Okay.
Class.
so they could revoke you based on, like, I don't know if they will, but they do have that option to revoke you for pleading guilty to this case. So
Okay.
do you understand that?
Yes.
Okay. We can move forward.
And are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes.
Do you understand that if you went to trial, you would have the right to a trial by jury? I'm sorry. Do you understand that by pleading guilty, you're giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the reduced charges of battery family violence and criminal trespass in indictment 26 SC 002071?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
You do not have a right to appeal directly from your guilty plea, but if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal. The discretionary appeal procedure is outlined in OCGA 5-6-35 and must be completed within 30 days of today.
Yes, ma'am.
Do Do you understand that you have only 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
And Your Honor, I have had an opportunity to speak with Ms. Gaddy several times. Initially, she was perfectly fine with the probation offer, the misdemeanor probation offers.
She is what connection to Mr. Gaddy?
Wife.
Wife, okay.
However, although they are going their separate ways, Ms. Gaddy actually asked me the other day if she didn't want to move forward, if I would dismiss the case, and I explained to her that we would not. So she's not unhappy with the state's offer. It's just not the result she was hoping for at this time.
But in the sense that she wishes it would go away, not in the sense that, how are you reducing it to misdemeanor? Why is he not going to the state system?
Correct.
Okay. But what she relayed to you is that she and Mr. Gaddy are not going to remain a couple.
That is correct.
Is that news to you?
No, sir.
Okay.
And Your Honor, if this case were to proceed to trial, the state would expect to show that on October 26, 2025, officers responded to Aaron Road Southwest in South Fulton, which is in Fulton County, Georgia. And they responded to a complaint made by Ms. Gaddy. Ms. Gaddy was visibly upset and advised that she had been involved in a physical altercation with her husband, Mr. Gaddy. She stated that they had been together for approximately 18 years, and she advised earlier in the evening they hosted a small couples gathering at the residence. After the guests left, an argument related to their current process of separation occurred, and Ms. Gaddy stated that while she was in the bathroom, Mr. Gaddy entered, confronted her, and during that argument placed both hands around her neck, choking her and pushing her against the mirror. She stated that Mr. Gaddy yelled at her while choking her that you have me effed up if you think I'm going to let someone else have you. Ms. Gaddy stated that she was unable to breathe and believed that she was about to lose consciousness. Ms. Gaddy stated she need Mr. Gaddy in the growing area to get free and ran downstairs to her adult son for help. She reported that while fleeing, she told her son to get him. And as Mr. Gaddy began gathering his belongings to leave, he removed a mounted television from the wall and exited the home. As he was outside, he struck her vehicle with a hammer, shattering multiple windows. And that concludes the state's portion, Your Honor.
Okay. So I understand sometimes after you interact with the alleged victim in the case, you would elect to downgrade the offense that alleges the physical violence and the nature of that. The hammer to the car is the seriousness of the offense is driven more by whatever it costs to fix. In the indictment, it says 7 windows and more than $500. Has Ms. Gaddy said it wasn't 7 windows or it wasn't $500? Or I'm just curious why you're downgrading that one. Not challenging it, but
No,
that's one where it was or it wasn't.
Ms. Gaddy has never provided us with documentation of that.
Okay.
At the indictment stage, typically there's a verbal conversation
Mhm.
and then there needs to be subsequent documentation to prove it.
Got it.
Based on her current state of not wanting to really move forward, Ms. Gaddy does not plan to provide me with such documentation.
Was there a body cam showing lots of broken windows on the Acadia?
There is visible physical damage to the vehicle. The state's issue would be proving the cost of that damage.
Got it. It's at minimum trespass. It's
Correct.
bashed up. But the value of that, you'd need cooperation from Ms. Gaddy.
Correct.
Okay. Got it. All right, criminal history.
It's like 2019 as it's all, I mean, it's simple self-conviction. I've seen it done.
Okay. Now you are on probation right now, Mr. Gaddy, for what?
Altercation I had with my son.
With your son?
Yes,
Okay. Is this the same son who was home when this happened?
yes, sir.
Okay, and is he an adult?
Yes, sir.
How old is he?
21.
Okay. All right. Did you share with me what the conditions were of probation?
Yes, Judge, I'll go back to them.
I know it's 24 months.
No violent contact, complete family violence intervention program, complete 60 hours of community service, and seek and maintain gainful employment.
Okay, so they can continue to interact, it just needs to not be tumultuous.
Yes, Judge, and I did speak with Ms. Gaddy about that because I actually mentioned to her that since they were dealing with an adult child, that typically I would just do no contact, but she said that she thinks that would make the separation process much harder.
Okay,
So she would prefer no violent.
got it. Okay, all right, Ms. Wood.
Thank you, Judge. It's my understanding that Mr. Gaddy has paid for the repair to the vehicle. So I wanted to share that with the court. As you heard, he's 44, he's a high school graduate, he has 3 children that he shares with her. He is eager to put this behind him so that they can hopefully move forward in a safe, productive, co-parenting way. And I believe that is all I have for the court. We just ask that you accept the state's recommendation.
All right, Mr. Gaddy, 3 kids. I've heard about the son, who you said is 21. I think you said
Yes.
21. How old are the others?
15 and want to be 9 Saturday.
Happy birthday. And the 15 and 9-year-old,
It's 2 15s, I'm sorry. They're twins.
oh, so they're 4, I guess the 21-year-old you don't think of as a kid so much because he's on his own.
Yes.
So a total of 4,
Yes,
2 15-year-olds and a 9-year-old.
yes, sir.
Got it. So the 3, I'll call them kids, the 3 kids, do they stay primarily with you or Ms. Gaddy or?
At the moment, they're with their mom, but once I get my residence, my kids are coming with me. We talked about it in separation and everything, so the kids will
Okay.
come.
And they'll visit you or they'll stay with you full-time?
Yes, sir.
Okay. Do you have a written arrangement with Ms. Gaddy about that?
That's something that we have to
Work through.
Yes.
Okay, all right. And tell me what kind of work you do.
I work for Home Depot Pro Warehouse in East Point. I'm a yard switcher in a GWA.
A what?
Yard switcher.
Yard switcher, meaning you move trucks around?
Yes, I'm.
Got it. You drive that funny looking little thing that just sort of pops them around in the yard. Got it. Okay, and that's a full-time?
Yes, sir.
All right. Do you have any questions about anything we've covered?
No, sir.
Judge, sorry, I forgot to add, in case you want to structure the sentence differently, he did serve 56 days for this case.
Oh, okay. Thank you. I forgot to check that. So the Aaron Road address, which is listed in here, is where this situation happened. Are you
Yes, sir.
still living at home?
No, sir.
Okay, but you are looking to secure a permanent residence and then the kids can be with you.
Yes, sir.
Right now, it's a temporary situation?
Yes, sir. Because I just got a promotion at my job, so I'm able to. My finances are able to where I can get my own place now, to where I can house my kids with me.
Okay, well, congratulations on that.
Thank you, sir.
All right. Well, if you don't have any questions, Mr. Gaddy, you've answered mine. I appreciate that. I find there's a factual basis for this plea. You and Ms. Gaddy are going to continue to go through a difficult situation as you disentangle after many, many years of being together. And you're going to need to make sure that the very natural emotions that flow from that you channel in a different way. You may feel very justified in being upset or hurt or whatnot, but you need to take it out on a punching bag or by running or pulling 2 trucks at once instead of 1, whatever it is that gets that out of your system. Obviously, what happened on the 26th, and I know there are 2 sides to it. I'm not saying it was just you jumping her, but we don't need to go there. Whatever happened, both of you would need to figure out a way to de-escalate that. But the focus is on you. You're the one who got arrested and the one with these charges. I am going to sentence you on count 1. Well, first, I find that, as I said, there's a factual basis for this. And two, that your plea is knowing, meaning you've understood what we talked about. And two, it's voluntary. No one is forcing you to enter this plea. Do you agree with that?
Yes, sir.
Okay. Ms. Wood, do you authorize someone at my office to sign the indictment on your behalf as well as your client's behalf?
Yes, Judge.
Ms. Willingham, can we get someone to sign for you?
Yes, Judge.
All right, we'll do that. Mr. Gaddy, count one, which is being reduced to family violence battery, and know this, that's your first and only misdemeanor family violence battery. If you are accused of and prosecuted for another putting your hands on someone who would constitute a family member, and that could be someone in the future who's not part of your family yet, and certainly it would be all your kids, that's a felony. So you're kind of using up your misdemeanors here. But it's a misdemeanor. And for that one, I'm sentencing you to 12 months to serve 2 months, but you'll get credit for the 2 months you already served with the balance on probation. Count two is 12 months probated consecutive. So instead of 24 months probation, it's 22 months probation. Special condition number one, the most important one, no violent contact with April Gaddy. Number two, you need to complete family violence intervention program. That's a series of classes, and you will need to enroll in the FVIP program within the first 2 months of your probation. Not finish it, but you got to get it started. So you'll provide proof of enrollment to your probation officer by the end of August, basically, 2 months from now.
Okay.
And then number three, you need to complete 60 hours of community service, and you need to do that within the first 6 months of your probation. That way, the tail end of your probation is just you living your own life, and you don't have these direct obligations, FVIP or community service to probation. And they may decide you took care of the substantive stuff, things are good with Ms. Gaddy, maybe they'll end it a little early, but that's based on how well you're doing with them. Ms. Wood, anything else on behalf of Mr. Gaddy?
No, Your Honor, thank you.
Ms. Willingham, on behalf of the state?
Nothing, Your Honor.
Okay. Did you fill out the magic form, or you will fill it out with your
Yes, sir.
client?
Yes, I'll
Okay.
get it back.
Please don't leave Mr. Gaddy until you and Ms. Wood fill out that form that will get to misdemeanor probation, all your contact information. They'll contact you. So if you get a strange phone call, if you want to let it go to voicemail, that's fine, but make sure you call them back. If they let me know, we've called him, we've emailed him, and you're not getting back, then I'll say, take out a warrant. I don't know what else to do. So definitely be responsive to them up front.
I will, sir.
All right, good luck.
Thank you.
Judge.
Are you Mr. White?
Yes, sir.
Oh, well, Ms. Wood just walked away.
Okay.
So we'll do one Rios matter, and then we can knock out your other one. Ms. Smith, you got lots of cases here. Is there one in particular you'd like, with Ms. Rios, that you'd like to do first?
Nothing in particular, we can do position 6, since he's the part 3 on first.
Michael Williams? Okay. He has a revocation? Mr. Williams does? I do.
It's 24/60/0/4/4/9.
And how much time is left?
1 year, 3 months, and then it's first.
Okay, thank you.
Yes. Is it big on the office? I mean, what do you? I'm here to.
Good morning, Mr. Williams.
Good morning.
Your lawyer's just working out one last thing in your case.
Yes, sir.
If I can have a real, yes, 11 months, 11 months, 9 to 10 days. So 10 more. Yeah, okay. So most of you did actually 10 minutes that way.
Yes, all right, thank you. You are.
Let me know when you're ready. Ms. Simpson, is there a basis for revocation beyond this situation? Mr. Williams, I'm gonna get us started. Ms. Smith is getting her files up and ready to go for your plea, but we're gonna get on the record in your case. It's 26 SC 996. You're represented by Ms. Rios. Both of you are here in court. Ms. Smith is representing the state. You're charged with burglary and some theft-related counts, and Ms. Rios tells me that you're ready to enter a plea. Is that correct? We're also going to talk about, you're on probation right now, and we're going to deal with that situation as well. It's going to be taking care of both things, okay? Ms. Smith, in a moment, is going to put you under oath. She will then ask you lots of questions about your case and about your rights. You need to answer all her questions. Speak loudly, please. But if any of the questions are confusing, or at any point you just need to take a break and speak with Ms. Rios, will you let me know that?
Yes, sir.
Okay, good. When you're ready, Ms. Smith.
Mr. Williams, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Michael Corey Antoine Williams.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
Negative.
Is there any medication that you would normally take that you haven't been given today?
Negative.
Are you able to read, write, and understand the English language?
Yes, ma'am.
How old are you and how far have you gone in school?
I'm 37 years old and 2 associate's degrees, one in automotive technology and one in mechanical engineering.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
Negative.
And are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
Yes.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
Yes.
Mr. Williams, do you remember being arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend a sentence to the court, which is 5 years to serve 10 months with the balance probated?
Yes, ma'am.
Can you repeat that, please?
Yes. Do you understand that this is a negotiated plea, which means that the state will recommend to the court a sentence of 5 years to serve 10 months with the balance probated?
Got it. I meant just the sentence part, but thank you.
Do you understand that that's the negotiated plea term?
Yes, ma'am.
Okay. Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yeah.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including
Yes.
on a federal case?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea?
Yeah.
Are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment. Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
Yes.
Mr. Williams, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, ma'am.
As to indictment number 26 SC 000996, how do you plead to count 1, burglary in the first degree, count 2, theft of lost/mislaid property, count 3, theft by taking, count 4, theft by taking, count 5, theft by taking, and count 6, theft by taking?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a direct right to appeal from your guilty plea conviction? But if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes, ma'am.
Do you also understand that that process must be completed within 30 days from today?
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you, Mr. Williams. Your Honor, if this case were to proceed to trial, the facts would show that on August 6, 2025, officers of the Atlanta Police Department responded to 210 Peachtree Street Northwest. That's the location of the Westin Hotel. When the officers got there, they spoke with the victim in this case, Mr. Cody Hamill. Last name is spelled Hamel. He stated to the officers that he was occupying room 571, 5710. And he advised that he went out later in the day. When he came back, his laptop, $5,000 in cash, his Glock, and his backpack were stolen from the hotel room. He told the officers that he is a US DEA agent and that all of the items that were stolen were government issued and belonged to the government, including the $5,000 in cash. Mr. Hamill was able to present his DEA badge to the officers, and they noted that in their police report that the items were government issued. At this time, the victim in this case, Mr. Hamill, told the officers that he did leave his room around 1 a.m. and then came back around 3, and those items were stolen. He said he had accidentally dropped his key card, and he believed a person picked it up and was able to get into his hotel that way. The officers then had a chance to speak with the security officer of the Westin Hotel, who stated that the access to the rooms could only be accessed through those key fobs or those key cards that they have. So they went back through the security footage, and the officers and the security guard went through the surveillance cameras where they saw the defendant in this case enter that Westin hotel room, and he was seen with the Nike backpack. At this time, the defendant was still not he wasn't at the Westin hotel, so the officers started to canvass the area. They did come upon the defendant where they found that Nike book bag, and they were able to recover most of the items that were stolen. So again, the items that were stolen was a cell phone that the government uses, a Glock 19, a laptop, and $5,000. The officers were able to recover everything except for $3,900 of that $5,000 that was stolen. The victim in this case, I had a chance to speak with him, and he told me that that $5,000 was going to be used for a buy, so that did not belong to him personally. However, I got a chance to speak with the legal department of his agency, and they said that they would be requesting restitution if possible. So at this time, the defendant was placed under arrest for the charges we have in front of us. The defendant told the officers that someone paid him to go to the room to take the bag. They gave him the key card, and he said he did not intentionally go into someone's room knowing that it belonged to another person. However, he was arrested for the charges we have in front of us. And all of this occurred in Fulton County also. Regarding the negotiated plea between the state and defense, we've agreed to sentence the defendant to 5 years to serve 10 months with the balance probated. It's my understanding that the defendant has been accepted into the Salvation Army program. So special conditions of probation is for the defendant to complete an anti-theft course and also successfully complete the Salvation Army program. Also, the state is going to be asking for restitution in this case. As I stated, I did get a chance to speak with the legal department, and if able, they would like to recover that $3,900 that was not recovered from the defendant.
Okay.
And that is all from the state, Your Honor.
Got it. Thank you. Criminal history information on Mr. Williams.
Reimbursement probation, development, by teachers. Permanent set. 24 SC 004. Yes, 2018 misdemeanor theft by deception. That's
Okay, thank you.
Mr. Williams, can I get your middle name and stated it wrong?
There's two of them, Corey and Antoine.
Could you spell it?
Cory, Antoine, Antuan.
T-U-N.
An.
Okay, thank you.
All right, I was just looking up the other case. Ms. Rios?
Yes, Your Honor. Mr. Williams is 37 years old. He's lived in Georgia most of his life. He did do 6 years in the Army. His mother also was in the Army, and he does not have any biological children. He was working for a mechanic shop in Lakewood, and he has 2 degrees in automotive technology and a 1 mechanical engineering degree. He has suffered from drug addiction for the last 10 years, with alcohol and cocaine being the source of his addiction. We got him into the Salvation Army to hopefully the program will address his addiction issues. I've spoken to his mom. It seems like he's a good person and just suffering from these things, and hopefully the program can help with that. He does not have an extensive history. So I'm hoping that you'll accept the plea as negotiated. And as far as the revocation, we're asking for him to be revoked the 10 months. So both the new case and the probation revocation are the same, so he can go to the Salvation Army. I've already reached out to my social worker, Ms. Ross, to get a transport order so he can have enough time. I know he is on some medication, so he would need to be transported with that. I know the state and probation are going to be asking for his first offender to be revoked. I'm asking that he keep his first offender status, and he understands that this new case will be making him a felon. So.
Okay, all right.
Oh, I'm sorry, one more thing. Ms. Ross just texted me to make sure probation's aware that he cannot have his phone for 30 days. But I think you guys know that with Salvation Army, like he can't, she said he cannot report, not report, but he won't have access to his phone for 30 days. But he can't leave for, okay, I think that's what it is. He can't leave for a certain amount of time. And maxing for his fees to be waived at least for 6 months.
Okay. Did you and Mr. Williams explore drug court or BHTC?
I usually always do. I can't remember if he was not accepted or is that we went up with the Salvation Army route because we thought that was, or Ms. Ross maybe thought that was a better fit. I'm not
Okay.
sure.
All right. And will the Salvation Army program provide housing initially? In other words, it starts out as a residential program.
Yes, Your Honor.
Okay. And do we have a sense of the duration?
I believe it's 6 months to a year.
Okay. Mr. Williams, I think Ms. Rios mentioned it, but your addiction is strongest alcohol and
Okay.
cocaine. Okay. And that's been a few years? All right. When did you serve in the Army?
Joined at 17 and completed 6 years.
Okay. Honorable, dishonorable discharge?
General under honorable conditions.
Pardon me?
General under honorable conditions,
Okay. Were you deployed overseas ever?
twice. My last duty station was South Korea.
Okay. Well, I appreciate your service. And is your mother, is she still in the Army?
She retired a little over 30 years, full bird colonel, 35 Fox military intelligence officer.
Okay. When you're done with the Salvation, when you complete the Salvation Army program, do you have friends or family you can stay with, or will you need to find your own place?
Actually, I was accepted to PAD as well. So,
Okay. They'll help you with housing.
yes.
All right. You've got a lot of support out there. I hope you use it wisely. Do you have any questions about anything we discussed?
No, sir.
Okay. Ms. Smith, Ms. Rios was saying that you've got a different view as to what to do with the revocation. Tell me your thoughts about the revocation.
Yes, Judge, they was gonna be asking for the defendant's first offender to be revoked. To be sentenced.
Okay. I am looking at the final disposition now. So it was a second degree burglary. He broke into a restaurant or pub and took some liquor. Well, it was 5 to serve 2 years, but those 2 years were reduced to time served. And then it was 3 years probation. And so if he were resentenced, what would the sentence would be? Basically 5 years to serve 10 months?
Yes.
Okay. All right. And Ms. Simpson, DCS has the same view that it should be a resentencing. And for both of you, Smith and Simpson, this is because of why we're here, that we've got another theft-related offense on the heels of a plea involving a theft-related offense. Okay. All right. And then last question for you, Ms. Smith. I followed the facts. It's not that, is it that they recognized from the security footage, we know that that's Mr. Williams, or it was there's someone leaving with a Nike backpack? That's the DEA agent's backpack. So we know someone went in the room. And then when they were canvassing the area around the West End, they found Mr. Williams with that backpack.
That's correct.
Okay, it wasn't, we know that to be Mr. Williams, we know that to be the backpack.
Right.
And everything was still in the backpack minus $3,900. Got it. Okay. Mr. Williams, anything you want to add about anything we've discussed? You don't have to add anything at all, but you have a right to say, hey, I want to tell you this or whatever. No? Okay. Anything else, Ms. Rios, from you?
No, Your Honor.
All right. Well, Mr. Williams, I am glad that this resolution will connect you to resources. Your last sentence, all it did was tell you to stay away from the social house. That's the place you had burgled. This one is connecting you with the Salvation Army and PAD. I hope that you take advantage of those programs to get the support and care that will assist you with the addiction. If that doesn't work out because you're on probation, it may be that we push harder to get you into one of our accountability courts for maybe a more comprehensive and longer term program to help work with your addiction or treat your addiction. So we'll see what happens. I do find there's a factual basis for your plea. Any idea what happened to the $3,900?
Yes. Most of it was taken with the other person, the one that paid me to go get the room, take the room key and go get the bag.
Got it.
That is why I was only caught with $1,100 because that is what I was paid.
Okay, so this other person who hired you to do this took the $3,900, but not the gun.
No, he left me with the backpack.
You just said, give me $3,900, and that was it.
Actually, I never even knew about the entirety of it until they told me how much it was.
The person left you $1,100.
Yes.
Okay, got it. Okay. Well, I find there's a factual basis. I also find that your plea is knowing, meaning you've understood what we talked about. You've told me you don't have any questions. And it's voluntary, meaning no one's forcing you to enter this plea, but you're ready to move forward with this. Is that correct?
Yes, sir. I was wrong.
Okay, I appreciate your candor. Ms. Rios, do you authorize someone in my office to sign the indictment on your behalf and Mr. Williams's behalf?
Yes, sir.
Ms. Smith, can someone in my office sign for you? Great. Mr. Williams, I will sentence you on count 1 of your indictment to 5 years to serve 10 months with the balance on probation. Count 2 is 10 months to serve. It's a misdemeanor. Counts 3 and 4 are 5 years to serve 10 months. And 5 and 6 are 10 months to serve. They'll all run concurrently with each other for a total sentence of 5 years to serve 10 months. You will get credit for the time you've served. Special condition of probation number 1 is that you enter into and complete at least 6 months of the Salvation Army program. Number 2, you're going to stay away from the Westin Peachtree Hotel. Can't go in there while you're on probation. Number 3, you are going to pay as you are able, $3,900 in restitution. That doesn't mean that if you work, all your income goes there. It is going to be entirely based on your ability to pay. So if you are earning some money, a little bit of that money will go to probation and they'll get it to the DEA. I will waive your probation supervision fees for the first 6 months because you'll be in the program. And we may need to extend that if you're still in the program. If you're not earning, but you're focused on recovery, then we'll keep waiving the fees. But I'll waive it for the first 6 months and we can revisit that if we need to. I can't require you to do PAD. They don't let that be. PAD doesn't let that be a condition of probation, but I'm encouraging you to stay plugged in with PAD. But that's on you. In 24 SC 004449, I'm going to revoke your first offender status and resentence you. I will resentence you on count 1 to 5 years to serve 10 months with the balance on probation. Count 2 will be the very same sentence. They'll run concurrently with each other and concurrently with the sentence in what I'm calling the Westin Hotel case. So it's not new time. It's just your probation will be running at the same time and go a little longer than it would have gone if you hadn't picked up the Westin case after you were working through the social house case. And in terms of special conditions for the social house case, the case ending in 449, it will be that you enter into and successfully complete at least 6 months with the Salvation Army program. And your supervision fees are waived there for 6 months as well. And you'll still need to stay away from the social house. Ms. Smith, anything else on behalf of the state? Ms. Rios, on behalf of Mr. Williams?
No, Your Honor, thank you.
Okay, do you need anything else, Ms. Simpson, to do? I guess you don't, you have to do some paperwork about probation, but it's really gonna be Ms. Nelson doing the resentencing of the 449 case. Okay, all right. Mr. Williams, good luck. I hope this program is something you embrace, and importantly, I hope it's something that works for you. Treatment is a way forward. You clearly are endowed with intelligence, educational background, professional background with the military, et cetera. And if we can get you in a stable space, and that may involve some medication as well, then I hope you're able to plug back in a way that's productive for you and avoids you getting stuck in situations like this. We'll see what happens. All right. Ms. Rios, you'll be getting an order. The sentences are going to say Mr. Williams is to be released pursuant to a separate order because he's done his 10 months.
Yes, yeah.
You are not getting out today. You're also not going to be stuck much longer, but I need to get a transport order from Ms. Rios, and that's going to require either Salvation Army to come get you or for the sheriff's team to transport you to Salvation Army. And once I get that, that'll be what releases you. This is next few days. It's just, I don't want you thinking, great, time served, I'm out today. We want to make sure that there is as seamless a handoff as possible from where you are now and Salvation Army, so you don't get detoured into a space you don't need to be in. Okay, thank you.
Get that order and see.
All right, do we want to do Mr. White
Yes.
now? Just as you got settled. Sorry, Ms. Smith.
Judge, I don't know if you guys are doing that, you could just hold off on Blue for a little bit. I'm probably Ms. Smith, fix some time.
Oh,
A
we'll,
little time consumption.
we will do Blue today, but the folks in custody will take in the order that you all need it to be. I just thought we'd do Mr. White because he's out on bond.
No, I'm fine with that.
Yeah.
I just didn't go through the next, and I just wanted to give her a little time.
Great, she can have time. Mr. White is the last non, 15. Page 5. Did you not get page 5? Okay.
Oh, wait.
We don't supply that. You got to bring me your own.
Right down.
Yeah, good, good, good. Let me know when you're ready. You're ready. All right. This is position 15. It's indictment 26 SC 002-090, State versus White. Mr. White is here. Good morning, sir.
Good morning.
With his lawyer, Ms. Wood, and Ms. Willingham is here for the state. Mr. White, Ms. Wood told me before you got here that you were prepared to enter a plea in your case. Is that correct?
Yes, sir.
Okay. Ms. Willingham's going to put you under oath in just a moment, ask you a bunch of questions. You've heard most of them already this morning, but it'll be your turn to answer them. I need you to let me know if you have questions at any time. Will you do that?
Yes, sir.
Okay. Ms. Willingham.
Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
You can put your hand up. Please state your true, correct, and legal name.
DeAndre Tez White.
Are you ready to spell your middle names?
How do QUATZ?
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
How old are you and how far have you gone in school?
I'm 35 and I completed 10th grade.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial?
Yes.
Have you had enough time to speak with your lawyer about all of the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes.
Counsel, Mr. White, do you need more time to discuss this case with your attorney?
No, ma'am.
Are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied your client has a full understanding of this proceeding?
I am.
Have you reviewed the indictment in this case?
We have.
Do you waive formal reading of the indictment?
So waived.
Has your client been arrested on these charges?
He has.
The state is unaware of any outstanding warrants related to these charges. Do you or your client know of any outstanding warrants related to these charges?
We do not.
Mr. White, has your attorney advised you of the minimum and maximum sentence for each charge you're pleading to?
Yes.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of, as to count one, it will be reduced to battery family violence, and that would have a 12-month probation sentence. Count two, 12 months probation to run consecutive to count one, for a total of 24 months probation. You would be required to have no contact with the victim, complete family violence intervention program, complete 60 hours of community service, seek and maintain gainful employment. Is this what was explained to you by your attorney?
Yes.
And you understand the court does not have to accept that recommendation and can sentence you to the maximum sentence on each charge and can run those sentences consecutively or one after the other. In this case, which would be 24 months in custody.
Yes.
I didn't hear an answer.
He
Yes.
said yes.
Yes, okay.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including in the federal courts?
Yes.
Are you on probation or parole for anything, anywhere?
Are you on probation? For a traffic ticket?
Yes.
Okay.
On probation for what?
Traffic ticket.
In what jurisdiction?
Lovejoy.
Where?
Lovejoy.
Lovejoy. Okay.
Do you understand that if you are currently on probation or parole, your probation or parole may be revoked based on your entering a guilty plea today?
Yes.
Are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes.
For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes.
Do you understand that you weigh any and all offenses, including any mental health offenses, by entering a plea of guilty?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights? The right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and the right to appeal if convicted of these charges after a trial.
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the reduced charge of battery family violence and count two, battery family violence? How do you plead to both counts, I'm sorry, of battery
Guilty.
family violence in this indictment?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
You do not have a right to appeal directly from your guilty plea, but if you believe there is some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal. The discretionary appeal procedure is outlined in OCGA 5-6-35 and must be completed within 30 days of today. Do you understand that you have only 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty?
Yes.
And, Your Honor, the state has had an opportunity to very briefly speak with the victim in this case. My investigator, Scully, first reached out to Ms. Jones and she had a very brief conversation with him where she explained to him that she has moved on, she's in a safe space, and she really doesn't want anything else to do with this case. She did speak to me. She said the same thing, and I see that she also was contacted by my victim advocate, at which time she asked that we stop calling her. But she is aware, that we were proceeding today with a plea. She was made aware of the plea agreement. So she is aware of what I even did get an opportunity to tell her what the offer was, and she emphasized that she just wants it to be over.
Okay.
If this case were to proceed to trial, the state would expect to show that on October 1st, 2025, officers were dispatched to 2500 Center Street, apartment C2, in response to a fight in progress. Upon arrival, officers spoke with Ms. Jones, who reported being assaulted by her ex-boyfriend, Mr. White. She stated that the incident began earlier in the morning when she told Mr. White she did not want him to walk her to the bus stop. However, he followed her and a verbal argument occurred. After returning home, the argument escalated. Ms. Jones reported that during the argument, Mr. White placed both hands around her neck and choked her until she lost consciousness. She regained consciousness and began to defend herself physically. Mr. White threw a bite at her and punched her on the left side of the face. The physical altercation continued before Mr. White left the scene. Ms. Jones advised that Mr. White was in a her and Mr. White were in a relationship for approximately 5 years and lived together at that location from lived together at a different location from 2019 until 2023. She stated that Mr. White currently resides at 2500 Center Street, apartment C, on 10. She positively identified Mr. White through DVS issued photographs, at which time warrants were taken out. EMS responded, and Ms. Jones, as Ms. Jones complained of pains in her throat and the left side of her face, she was transported to Brady.
That's it.
And that is all from the state.
That's okay. Thank you. And criminal history for Mr. White.
Never cycles. You don't have any felony convictions.
All right.
He live in the freight.
All right. Got it. Ms. Wood.
Thank you, Judge. Mr. White's 35 years old. He has a 10th grade education, as you heard. He's currently gainfully employed. He works for a flooring company. He's headed there after we wrap up here. He's eager to get this behind him. No issues with the no contact. He is asking the court to consider waiving his probation fees so that he can get started right away on the family violence intervention program. And then also he is asking the court to consider suspending or terminating his probation after a period of compliance and after he completes all special conditions. And that's all we have.
All right. Mr. White, tell me what you do for the flooring company.
I do flake floors, epoxy, and SPS is like hospital floors,
What's a flake floor?
like what they have in hospitals. We concrete polish. We
So you would go into the hospital and make the floor nicer, or you install it like when they're building a new hospital?
I make it nicer.
Okay, got it. Did you and Ms. Jones have any kids?
No, sir.
So you don't have any reason to be connected with her anymore?
No, sir.
She's gone her way and you're going your way?
Yes, sir.
Okay. Do you both still live at, what's the apartment complex called?
Etheridge.
Etheridge Court, right. Do you both still live there?
No.
You live there, she's moved,
She's lived there. I moved.
you've moved?
Yes.
Okay. All right, that's not in the system. You may want to update that because it's got you at apartment C110 at Etheridge Court. So it'd be good for us to be able, if we need to get something to you, update the address. Do you have questions about anything we've been discussing?
Not really, no, sir.
Okay. Well, Mr. White, I find there's a factual basis for your plea. I trust there's more to the story than what Ms. Jones relayed to law enforcement, but it sounds like she had some visible evidence that whatever you two were into ended up with her getting injured, and you are accepting responsibility for that. I also find that your plea is knowing, meaning you've understood what we've been talking about, and voluntary, meaning no one's forcing you to enter this plea. Do you agree with both those things?
Yes, sir.
Ms. Wood, can someone in my office sign the indictment on your behalf and Mr. White's behalf?
Yes, Judge.
And for you, Ms. Willingham?
Yes.
Great. So, Mr. White, I will follow the negotiated resolution. Your sentence as to count one is, which has been reduced to a misdemeanor, is 12 months on probation. Count two is 12 months on probation to run consecutive to count one. So it's a total of 24 months. Special condition number one, the most important one, no contact with Ms. Jones. That should be pretty easy since you don't have kids together, and I'm sure you have shared friends, but don't use those friends to say, hey, how's she doing? Or anything else.
I'm talking about she talked to.
Okay, we'll keep it that way. Social media makes that a little complicated. You don't do social media.
I do, but I don't contact nobody.
Okay.
I just go look.
Good. All right, keep it that way.
Neighborhood.
Special condition number two is that you will complete the Family Violence Intervention Program. And I'm requiring that you enroll in that within the first 2 months of probation. So don't sit around, at least get plugged into it. It takes a while to finish. I'm not saying you finish it in the first 2 months, but you have to start it within the first 2 months. And you'll need to complete 60 hours of community service. And you'll need to do that within the first 6 months of your probation. And I will waive your probation supervision fees for the first 4 months of probation. So you can be focused on spending on the Family Violence Intervention Program, because those classes aren't free, rather than on your supervision. In terms of early release from probation, I'm going to leave that to probation. If you are doing well and taking care of these things that I've already put time limits on, they're going to want to have you roll off early because they have other people who are higher maintenance. So if you are low key, you could earn a request from them, which I would likely grant, to say, could we just roll off of Mr. White's case early? And if everything's gone well and you've done your family violence intervention and community service, the answer would probably be yes. Okay?
Yes, sir.
They're going to contact you. You don't show up at their office. Their office is actually very near here. But Ms. Wood has filled out a form that has your email, your cell phone. And so you may not answer the phone when they call because you don't recognize the number, but they'll leave a message. Make sure you call them back. Or if it's an email, you write them back. Because if they can't reach you, that ends up being your problem, not theirs. They just let me know, hey, White's a no-show. And then I got to sign a warrant and we start this all over again. Okay?
Yes, sir.
Ms. Willingham, anything else for the state?
No,
Ms. Wood for Mr. White?
no, Judge, thank you.
All right. If Ms. Wood has filled out address change form for you and the form for misdemeanor probation, you're good to go.
You're good to go. Mr. White, you're welcome. Judge, may I approach?
Yes.
This is, the address change and the probation for Mr. White and then Mr. Gaddy's.
Interesting pen color.
Yes.
All right. Thank you.
Okay.
So this address for Mr. Gaddy is still Aaron.
So right now, he's moving and I told him to make sure that he
Lets them know.
gets that, yes.
Okay.
Correct.
Great. Those of you in the front row, you are here for what case? Say it again? Blue. All right. It sounds like there are a few more technical details they're working through on that. So we will turn to that as soon as the state says they've got their paperwork in place. In the meantime, what are we doing now, Ms. Rios? Spencer? Spencer.
Oh, okay. They're gonna went out here. Okay.
Gotta move.
Come on.
Let me know when you're ready. You're ready. Okay. Let's go on the record. We have two cases with Mr. Spencer, positions 7 and 8, 26 SC 001266 and 22 SC 180 465. Good morning, Mr. Spencer.
Morning, sir.
Mr. Spencer is here with Ms. Rios as his lawyer. Ms. Smith is here for the state. Mr. Spencer, Ms. Rios tells me you are prepared to enter pleas in both of your cases. Is that correct?
Yes, Your Honor.
Okay. Ms. Smith will put you under oath in just a moment, ask you a series of questions about your rights and your cases. Please answer her questions truthfully and completely. It is just as important that you let me know if you have questions that need to be answered. Most of the time, you'll be answering questions, but if there's something you don't understand or you're confused by something, or you just need to speak with Ms. Rios, you'll let me know?
Yes, sir.
Great. Ms. Smith.
Thank you, Judge. Mr. Spencer, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Aaron Michael McCreary Spencer.
Can you spell your second middle name?
It is my primary birth last name.
Okay, whatever one that is, spell it.
McCreery.
Thank you.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
Medicine.
Okay, what medications are those?
Remeron and Zyprexa.
Tell me for what diagnosis you take those medications.
Zyprexa is to battle my depression. I suffer from manic depressive and suicidal tendencies, and Remeron is to battle my sleep difficulties. I have difficulty sleeping.
Okay. When do you typically take the sleep medication?
I take the sleep medication at approximately 9 p.m. each night.
Did you get it last night?
Yes.
And the depression medication you take when?
I take that also at 9 at night.
Did you get it last night?
Yes, sir.
Do either of those medications have lasting effects such that the next morning, where we are now, you are left woozy, drowsy, confused?
No, sir.
You feel like you understand what we're doing?
Yes, sir.
Are you at this time, sorry, how old are you and how far have you gone in school?
My age is currently 34. I went to the 11th grade before finishing with my general education diploma.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in both of these indictments?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with her services?
Yes, ma'am.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
Yes.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
Yes.
Mr. Spencer, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No, ma'am.
Do you understand that this is a non-negotiated or a blind plea and that the state will recommend a sentence to the court? Is it?
Enter 3.
Okay.
Do you guys need to confer?
Okay. I mean, you like a copy.
Well, actually more. He's been in for 3 years and 1 month on the most recent arrest. For the 22 SC case, he served a year before he was released, and he gets credit for this as well. So in connection with that case, he served 4 years and 1 month. So for the 26 SC case, 3 years. For the 22 SC case, 4 years.
All right. Mr. Spencer, do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 10 years to serve 3 with the balance probated?
Yes, ma'am.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes, ma'am.
Do you also understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea?
Yes, ma'am.
Are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes, ma'am.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by entering this guilty plea?
Yes.
Mr. Spencer, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea today?
No, ma'am.
As to indictment number 22 SC 180465, how do you plead to count 1 aggravated battery?
Guilty.
As to indictment number 26 SC 001266, how do you plead to count 1 willful obstruction of law enforcement officers by use of threats or violence, count 2 riot in a penal institution, and count 3 simple battery?
Guilty, ma'am.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a direct right to appeal from your guilty plea conviction? But if you believe that there's some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes, ma'am.
Do you understand that that process must be completed within 30 days from today?
Yes, ma'am.
Do you also understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Thank you, Mr. Spencer. Your Honor, in this case, starting with the oldest indictment ending in 465, if this case were to proceed to trial, the state would show, or the facts would show, that on February 21st, 2020, officers with the Atlanta Police Department was dispatched to 22 14th Street regarding a battery case. When the officers got there, they spoke with the victim, Mr. John Wise, who stated that he was walking toward a establishment, or I believe some type of restaurant, when the arrestee, Mr. Spencer in this case, punched him in the face. Mr. Wise advised that he did not know Mr. Spencer. They were not friends. They had not been together in the past or anything like that, and that he was a stranger to him. Mr. Wise advised the officers that he was crossing paths with Mr. Spencer when Mr. Spencer started moving and dancing awkwardly, and then out of nowhere just punched Mr. Wise in the face. Mr. Wise had a bleeding laceration along the swellings of his face. There was a witness on scene who told the officers kind of the same thing that Mr. Wise told the officers, that Mr. Spencer in this case just kind of came out of nowhere and punched Mr. Wise in the face. Mr. Wise was taken to Grady Hospital, where he was treated. He had lacerations on his face. His face was bloody, and I have some pictures of those that I spoke with Mr. Wise about showing today. But I think because he's taken the plea, we're okay with not showing those photos. I did get a chance to speak with Mr. Wise. He is on the call. He said that he would like to be on the call, but he doesn't want to make a statement. He was okay with basically summarizing what we've talked about, which is this was something that came out of nowhere, kind of has impacted his life. However, he is okay with the offer in this case, and supports the plea that the defendant is doing today. Regarding the negotiated plea between state and defense, we've agreed to a sentence of 10 years to serve 3 with the balance probated. Regarding the special conditions of probation, like I stated earlier, the defendant and victim, they are strangers. However, we're asking for no contact with the victim in this case, just in case he sees them again. We're asking for the defendant to complete an anger management course and also a mental health evaluation with treatment if necessary, and alcohol and drug abuse evaluation with treatment if necessary. And that is all from the state.
All right. What about the other case?
That is correct, Judge. There's another case. Regarding the facts and circumstances of the indictment ending in 266, the facts would show that on February 18th, 2025, the defendant in this case was housed at the Fulton County Jail. He got into a physical altercation with the detention officer, Tony Cook, and also an inmate, Centrice Reed. There was an initial physical altercation between inmate Reed and the defendant in this case, where the defendant punched Mr. Reed in the face. Detention officer Tony Cook came to break up that fight. And when he came to break up the fight, the defendant in this case, as is reported, punched Mr. Reed and bit him on the left arm. At this time, the defendant was tased and he was detained for this assault on the inmate and on the detention officer. Both of these cases happened in Fulton County, but those are the facts and circumstances of 266.
Got it. Thank you. Let me look one thing up. Okay. Criminal history information.
2024 ag battery trespass conviction. 2022 battery conviction. That's 2018 arrest for felony obstruction. 2015 assault battery.
Out of what? Out of state. Okay, thank you. Ms. Smith, there is a recidivist notice in the 22 SC case. Are you waiving that for purposes of it's sort of moot given what the sentence is, but we just need to have the record clear. Either you're enforcing it or you're waiving it. Waiving it. Okay. All right. Ms. Rios, tell me a little bit about Mr. Spencer. Looks like a complicated situation. He was in jail for 3 years. Not on either of these cases. One of these cases occurred after he'd been in for 2 years, but it was the case with Judge Cox where he ultimately pled to time served for biting a piece of someone's ear off.
Yeah.
So what's going on?
He suffered with alcohol addiction for a while. We've talked, and since he's been in jail for 3 years, hasn't had access to alcohol. And he says that doesn't think he needs any assistance, that he's be good. He's been sober for 3 years and he thinks he'll have a handle on his life when he is released. He's 34 years old. He's originally from Detroit, but lived in Atlanta for the last 8 or 9 years. He moved here, he said, because of the weather and just for new opportunities. He does not have any children. He did complete his GED, and he does have some experience in landscaping work. So when he gets out, he's going to try to get a job doing that. He can go back to Atlanta Rescue Mission. He'll go there to get on his feet. We did do a referral to PAD, but they did not accept him due to the charges.
Okay.
So I just ask that you accept the plea as negotiated and waive probation fees for 6 months, but if not inclined to 6 months, at least 3 months.
Okay. Mr. Spencer, I've got a couple questions for you, and then if there's anything you want to add, I'm happy to hear from you. I think Ms. Rios answered one of my questions, which is you don't have a place to stay when you get out. You don't have family here or friends where it would be safe for you to stay, so you're prepared to start out at a shelter?
Yes, I stay predominantly when on the outside world at the Atlanta Rescue Mission or at the outreach program located on 3rd Street.
Okay, so you have an idea of where to go?
Yes, sir.
Okay. All right. Do you have family back in Detroit?
Yes, yes.
Okay. Are they a resource for you, or that's not really a connection you have anymore?
They would help me, but they've helped me so much in the past that I feel bad asking them for help.
Okay. All right. Mr. Wise, who is the victim in this case from long ago, 2020, but obviously it meant something pretty serious to him because he's taken time out of his day today, 6.5 years later, to listen to the proceedings. A stranger to you?
Yes.
Okay. And when this incident happened, was it a psychotic episode? Was it an addiction-related episode, or a combination of the two?
Neither. That day, as stated, it was very, very hot. I'm from Detroit, which hottest during the winter it gets is about 12 degrees. And so this particular winter day, it was 90 degrees. And so I was suffering from heat stress. And I was trying to ask him for help, but I was intensely impacted by the heat. And so instead of being able to ask him if he would buy me a soda, I just freaked out and swung at him whilst in the middle of asking him for spare change.
Okay. And then the situation with the case you had with Judge Cox, the ear, a stranger to you or someone you knew?
A stranger, Your Honor.
Okay. All right. Well, Mr. Spencer, I hope that you avail yourself of some of the supports that are out there. I think that the evaluations that you're going to get may lead to some good recommendations for treatment. You are going to need to work hard to reconnect with medication support. The sheriff's office has unfortunately greatly reduced the size of the supply of medication that I can require them to give you when you leave. And you take medication for important reasons, helping you sleep, helping you manage manic depressive situations. And I don't know that you're going to get a very large supply of that. And then you will have no medication when that runs out. The sheriff may rethink this policy because that will result in some people going right back to jail, which is what we call cutting off your nose to spite your face. But I hope you have resources in place, and maybe one of the shelters where you stay, they can connect you with Mercy Care or Grady or whatnot, and you'll be able to re-up the meds. But they are important because in my experience, people who struggle with what you struggle with, if they can't get prescription medication, they find other ways to feel better. And those aren't always legal, and then they lead to complications, and your ice is very thin. You'll be on probation, but the next judge to get your case, if you have another case, is going to look at what you've been doing and been through, and you're going to get locked up again for a long time. So I encourage you, one, to take advantage of the resources that are out there, and two, make it one of your top missions to get back on medication. And I wish I could get you a larger supply, but there is a recent change, and you may leave with as few as 4-day supply of medication. I could not refill a prescription in 4 days if I wanted to, because I'd have to get my doctor to mail something in or phone it in, and then I get to, and I got all sorts of resources that you don't. So I'm worried about that piece. And that's not your fault that you're leaving with a 4-day supply of generic medications that probably cost $10, but that's not a decision that I get to make right now. So here's what we're going to do. I find there's a factual basis for both your pleas, and I find that both your pleas are knowing and voluntary, meaning you've understood what we talked about. Fair? Yes?
Yes, yes.
And voluntary, no one's forcing you to enter these pleas. Also, you agree with that?
Yes, Your Honor.
Okay. So I'm accepting your pleas. And I want to confirm, Mr. Wise, that there's nothing you want to add. I know you're on the call. I'm not calling you out, but Ms. Smith relayed to me that you were good to go, simply observing what's going on. I just need you to confirm that I'm not preventing you from giving an impact statement. All right, I'll take that silence as he's good to go. Ms. Rios, do you authorize someone in my office to sign both indictments on your behalf as well as Mr. Spencer's behalf?
Yes, sir.
Ms. Smith, can someone in my office sign both indictments for you? Okay. Mr. Spencer, in 26 SC 001266, your sentence on count 1 is 1 year to serve, count 2 is 1 year to serve, and count 3 is 12 months to serve. Those will all run concurrently with each other, and you will get credit from February 26, 2025. We gave you some bad math earlier when we said, hey, you've been in for 3 years, you get credit for 3 years. You can't get credit for time you served before the incident. And you're getting into it with Detention Officer Cook and inmate Reed. Didn't happen until February of last year. You certainly get credit for every day since then, and that's been more than a year. So a year to serve basically on that case. In 22 SC 180465, that's the case in which Mr. Wise is the victim. It's 1 count, and your sentence in that case is 10 years to serve 4 years with a balance on probation. You'll get credit for the time you served in connection with that case, which is in 2 pieces. There was a year to serve originally until you made bond, and there's been an additional 3 years plus since you were last taken into custody, and that was in connection with the ear case. So 10 years to serve 4 years, balance on probation. Special condition of probation number 1, probably the most important one, is you leave Mr. Wise alone.
Yes.
He's a stranger, that should be the easiest condition, but don't use social media to try to track him down to say, I'm sorry, or you should have bought me a soda or whatever. He goes his way, and hopefully today is the last day he needs to think about these proceedings. Special condition number 2 is that you submit to a mental health evaluation, and that's for you to get with a medical professional, likely at Grady, and that professional will work with you to say, what's the right regimen? Is it medication? Is it counseling? Is it what? But whatever treatment that professional recommends becomes a condition of your probation. So if that professional says you need to take Zyprexa, that's not optional for you. You take that as a condition of probation. You will also have a drug and alcohol abuse evaluation. And again, if there's treatment recommended, that treatment becomes part of your probation. Go to an NA meeting or a this or a that. That'll be something you'll need to do as part of probation. I will waive your probation supervision fees for the first 3 months of probation while you are getting settled. And then if you are not working at least 10 hours a week by the end of 3 months of probation, then you're going to have 10 hours of community service each week. So we'll get you engaged one way or the other. If you land a job, landscaping, whatever it is, needs to be at least 10 hours a week. And if it is, then there's no community service. But after those first 3 months of probation are up, for each week you're not working 10 hours, then it will be 10 hours of community service, so that you are having some engagement other than whatever else is going on in your life. All right? Questions about that?
Only one. So does that mean that I have a year remaining to sit in jail?
No, sir. You served 1 year on the case involving Mr. Wise before you were released. You get credit for that. You have since been in for another 3 years and 1 month. And statutorily, you get credit for that, even though you were in for something completely different. That is custodial time subsequent to the offense you're pleading guilty to. The offense you're pleading guilty to is the aggravated battery on Mr. Wise. And so you served 4 years for that, and no one can ignore that. And people shouldn't look at this saying, he got a time served sentence. You didn't. You got a sentence of 10 years to serve 4 years. And unlike many people who get a 10 to serve 4, you served every day of the 4 years. If you had received a 10 to serve 4 sentence 1 month after you did what you did to Mr. Wise, you would have been out of the prison system within a year. You would have served probably a third of your sentence. Here, you served every day plus a bonus month of the 4 years of your sentence. But you will be released. I can't promise it would be today, but it ought to be this week because you've served the 4 years.
Thank you so very much, Your Honor.
Ms. Rios, anything else on behalf of Mr. Spencer?
No, thank you.
Ms. Smith? Okay. Thank you, everyone.
Is it okay? I think, do you have something? Yeah, but you can't go back. You're right. Can I go back and speak briefly with Mark briefly?
Sure, we can take a 5-minute break. Court reporter can stretch, get some Java, and I may be back out here before then, but that's fine. Let's try to keep it to 5 minutes. Yeah. Hi, Ms. Tembeka.
Happy to see you today, you know, on negotiations I brought you to the court. I'm just taking you my word over the day. Jump in on C on 29.
Woo, all right, that's gonna be a fun day.
Oh, Judge, do I look now?
You may,
Oh, smart kid.
and I'll introduce you to mine.
Okay. Fancy you guys here. The judge is trading. You go into his 3rd year at UGA, spent his last summer studying last semester studying at Oxford, last summer in Berlin. I mean, super impressive kid.
Wow.
He's interested in indigent defense, which is how he got linked up with me. And I told him, well, you're gonna meet any judges.
Let's do it.
Yeah.
So you will be a 3L at UGA?
Undergrad.
Oh, 3, like a junior at, all right. My intern is Ben Hayes. He is a rising 3L at Emory, also interested in indigent defense.
We must meet, we must connect. This is God's work.
So Ms. Tembeka does some indigent work. She's got her own firm, but helps out with the conflict cases where the public defender can't represent 2 people on a case. Well, this is the lawyer for Mr. Thomas. He's helping me with the Jackson Deno. I had him review it as well and said, hey, here's how Jackson Deno works. I said, but it's a juvenile, so you got some other factors you need to weigh. So this has been great for Ben.
Person, you know, we actually just had to argue one in front of Judge Whitaker. And I was like, oh, we didn't come with a long law. That's okay. She's practically the appellate.
Right, she is. I mean, she can reverse herself if she gets it wrong.
That's right. It was like, we're in good hands. You're in good hands.
Excellent. All right, you go work with Ms. Smith. Okay. Small world. We're down to 1 piece of candy. What's wrong with the blue?
Not at me, just. But I will have it. Okay, plan on bringing it. Okay. Oh. I think this is. Oh, sure. Christian.
Well, can you hand me the dish? As long as it's not blue, you'll eat it. I'll be right back.
Oh, 80 and I already don't know. I told myself, I don't know, but she didn't make that up. So no people that's not, they wouldn't know. I don't know, but I believe it. So. Yes, and so this is having the sense with the autism. What is, I'm not speaking it as I saw you know. Yeah. What is
just came up with it. Okay. I was trying to get, certain green. Maybe I think I had a program. Search of, you do the community stuff. They're waiting for
the blue king?
Are you talking about the big?
No, she wasn't. Yeah, have it.
Or the blue king?
If you want to, man, first of all, I was giving it to you. Don't try to take mine. You saw she. I was giving you again. See that? Yeah, she did. Look, it's from me, from your table, from your table.
It's still, you still get an SC number, it's just a different process. It doesn't have to go to.
Sure.
Oh, okay.
Yeah.
We have an SC. No, we still get an SC number.
So you had to just in all this part.
Yeah.
What it is.
Correct, to the first. Every employee, they have a short, enough big ones that you can do with one. Starting on.
On the same
So we put it down. Time for this, I'm going to do that. It's been very. Yes, that's right. So, okay, what about you? I think. I'm not sure. It's just easier.
Everybody needs that. We need.
So did you want to do these things? Yeah. I just want to make sure that
Well, they're trying to. Yeah.
I love it. I love it. It's really nice. That's what my heart is. What's the?
No, it can go on your desk. It's not allowed to be too close to Ms. Rios.
But it was the Western Hotel. I was in it.
Oh, I like your candy the other day. You know, that was for me, by the way.
Is that, so that's you? You solved the mystery. I've been trying to figure that out. It was essential, given that case.
I saw you in the hall and said you were having trouble staying.
That explains, no, Jolly Ranchers and my favorite, Reese's Peanut Butter Cups.
I didn't even know. I was in.
Home run. Thank you.
Mystery solved.
Uh-huh.
Thank you.
My secret source. All right, let's get back to all the pleas we need to do. Are we ready on blue yet?
I think so, Judge. I emailed the first office. We're waiting on them to respond.
Okay.
But I think it should be good. I'm gonna take my laptop with me. If there are any issues, I will fix it, but I'll give this, update as soon as.
So we have new indictment numbers.
You haven't?
No, I was asking if we had that.
No, there were some technical issues that they needed fixed before they issued the indictment numbers.
Okay.
So I just finally finished all of that.
And you sent them back to the clerk's office?
Yes, so hopefully that will now generate indictment number.
Okay,
So I'm hoping in the next 5 or 10 minutes.
okay. All right, let's do another plea then.
Okay, so I'm ready on Larry Phillips, Judge. Can you look on Zoom and see if there's an Andre Benjamin on the call?
Sure. Nope.
Okay. We'll go forward without Mr. Benjamin here and I'll just tell you about the program.
Okay.
I was multitasking.
No, Benjamin is someone from it's Phillips. Phillips is the plea. Benjamin is someone from the program he'd be joining. Thought we threw you a little curveball. Come on, Benjamin. So we're ready for Mr. Phillips, please. Okay. Sure.
So what you went through with trying to stay awake is what he's going through down there now. Civils, bench trial.
Yeah, and this was one, they had jurors here, but they just,
Oh, I know.
they weren't attuned to engaging the jurors.
Yeah, they didn't use technology.
No, not at all. And I show you exhibit 37F, and it's this giant document, and turn to this page. And so the witness and the lawyer can see it, and that's it. And what does that say? It says that the property goes to, and the I don't know what's going on. They don't know what's going on. Fortunately, it's settled just before deliberations,
Oh, seriously? Yeah, so you have to sit through all that for.
but no appeal,
Yeah,
and
that's true.
the jury didn't have to wrestle with, all they would have been given this, and they'd say, figure out how much A owes to B. Go. And are we okay, or you're missing someone?
They took somebody in custody next door, so she can have my keys. I'm looking at the keys, you know, so.
Okay.
One of the exhibits was too big to claim. So they had it was a disc.
Huh?
And they showed a bunch of them up on the screen. Well, during deliberations, the jurors were like, we want to see that exhibit. And they're like, well, you'll have to come to the courtroom and they.
Then you can't talk about it.
Exactly.
Yeah.
And I'm like, well, why don't you just give the computer?
A laptop. Yeah.
Oh, well, then I go on.
Here comes someone. Dun, dun, dun. Did you steal our key? Yeah. Shh.
So that was messed up. They didn't come out and they just scrolled through,
Yeah.
couldn't talk to each other. They're trying.
Yeah. And stop on that page, magnify. Yeah. They should have planned for that. And here's a clean laptop.
They didn't want my minutes.
Clearly.
To the point of asking what's right.
How are you? Just 5 days probation, to 6 months. You're almost done with that in like less than 2 weeks. And then the Benjamin program, okay?
Oh, that's good. Yeah.
So it's just the 5 through 6 months and then the Benjamin program and contact that course and stay on this allocation, okay? Right. So you get credit. Yes, sir. So you get credit for all of that, okay? Try to be ready.
All right. Let's go on the record with position 3, State versus Larry Phillips, 26 SC 000280. Good morning, Mr. Phillips.
How you doing?
Okay, are you okay standing, or is it better if you sit?
My leg hurt, but I do.
Okay, if you need to sit at some point, will you let me know?
Yes, sir.
Okay. Mr. Phillips is represented by Ms. Wood here in court. Ms. Smith is here for the state. And Mr. Phillips, we're going to try to take a plea in your case. Ms. Wood has been working hard with Ms. Ross and others from her office to line something up for you. So we'll see what happens here. Ms. Smith is going to put you under oath in just a moment and then ask you about your case and your rights. I need you to not jingle your chains while you're doing this, or the court reporter will get mad at me. You need to answer all of Ms. Smith's questions. If at any point you've got questions, you need to take a break, you want to sit down, let me know, okay?
Judge, I think we should probably sit down.
Okay,
Anita,
let's do that.
just so we'll all stay.
Ms. Rios can move towards her candy bowl.
All right, so you go that way. And thank you, Judge. Wait, where else can you go? Wait, actually. Best day ever.
All right, same rules apply. I need you to move closer to the microphone, so wheel on up in that chair, so that we can all hear you. And make sure you answer loudly and clearly all of Ms. Smith's questions. Okay, Ms. Smith?
Yes, Judge, thank you. Mr. Phillips, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Araldo.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
Not shy of medicine. What you mean, like now?
Are you taking any medication right now?
Have earlier this morning,
Okay, tell me what you take medication for.
psychiatry.
Not what it is, but what do you take it for?
I take,
Like, do you take it because you have a bad back or because of depression or diabetes?
one from diabetic, and I take I have seizures.
Do you take any medication for mental health? Okay. Did you get all the medications that you normally take in the morning? Did you get them this morning? And did you take them?
Yes, sir.
When you take those medications, do they make you sleepy or drowsy or confused?
Sleep.
Oh, okay. Do you feel sleepy right now? Do you feel like you understand what's going on? Okay. Do you take some medication at night? Did you get it last night? All right, we'll keep going.
Mr. Phillips, how old are you and how far have you gone in school?
I went in fifth grade in school, and I'll be 58 in July, one night.
Are you able to read, write, and understand the English language?
Yes.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial. Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment? Do you need more time to discuss your case with your attorney? And are you satisfied with her services? Counsel, are you satisfied that your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
So wait,
Mr. Phillips, do you remember being arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
we are not.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 5 years to serve 6 months with the balance probated?
Yes.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively? Yes, okay. Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence? Do you understand that this is a guilty plea, which is permanently recorded on your criminal history? Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including in a federal case? Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea? Are you a United States citizen? Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment. Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense? Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes.
Do you also understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes.
Counsel, are you satisfied that your client understands that these are the rights they'll be waiving by entering this guilty plea?
I am.
Mr. Phillips, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea? As to indictment number 26 SC 000280, how do you plead to count 1, financial transaction card fraud, counts 2 through 6, financial transaction card theft, and count 7, giving false information to law enforcement officers?
Yeah.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a direct right to appeal from your guilty plea conviction? But if you believe that there's some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes.
Do you understand that that process must be completed within 30 days from today? Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes.
Thank you, Mr. Phillips. Your Honor, if this case were to proceed to trial, the facts would show that on January 4th, 2026, officers of the Atlanta Police Department got a forgery call at 5110 Old National Highway at Legends Cafe. When the officers got there, they spoke with the worker of the Legends Cafe, who told the officers that someone was there trying to use another person's card. The worker stated that the person who came in trying to use someone else's card frequents the area and could be seen begging for money from time to time. She stated that the person came in with a new wallet that the worker felt like was not his because she sees him regularly. The officer was able to make contact with the male subject, who was later identified as the defendant in this case. The officer asked him, did he make a purchase with someone else's card? He said no, and that someone from his family sent him to the store with that card. When the officer asked what his name was, he said Larry Thomas. The officers ran that name through GCIC and it came back as not the defendant in this case. The defendant in this case, he was taken into custody. The officer then asked him for his name again, and he identified himself as Larry Phillips, who he was. Mr. Phillips was searched before he was placed into the patrol car. And during the search, the officers found multiple debit cards on his person, and those debit cards belonged to the victims in this case: Felicia Conley, Justin Jones, Brittany Lee, and Adam Muswee. Last name is spelled Mushaweh. Also, the officers were able to obtain a receipt from that Legends Cafe because the defendant did make a purchase for the amount of $39.85. At this time, the defendant was arrested for the charges we have in front of us. Also, this occurred in Fulton County. Regarding the negotiated plea between the state and defense, we're asking for 5 years to serve 6 months with the balance probated. Regarding the special conditions of probation, the state is asking for the defendant to complete an anti-theft course to stay away from the incident location, so Legends Cafe, for the defendant to complete an alcohol and drug abuse evaluation with treatment if necessary, and for the defendant to successfully enter and complete the Benjamin House program. That is all from the state, Your Honor.
Okay. Thank you. Criminal history for Mr. Phillips. At least 50 cycles. Okay. I have a little bit about his past through the repeat offender notice. They listed 6 felony convictions. They're all pretty old. So if you've got anything more recent than, say, 2015, I'd be interested in hearing about that.
I'm gonna say it's then, it's 2022 possession code.
Okay. Was that in Fulton County? Okay.
But you see the old ones, right?
It was Cobb? Yeah, no, I see there are lots of old ones, and some of them are on the notice that the DA's office put together. But we've got more. Okay. Got it. Cobb. Is Mr. Phillips on probation out of Cobb? Oh.
That's since completed January next year.
Okay. Got it. Ms. Wood,
Thank you, Judge. Mr. Phillips is 58 years old. He is from Atlanta. As you heard, he does have a fifth grade education. Judge, he is disabled. He suffers from paranoid schizophrenia, diabetes, as well as epilepsy. He has been self-medicating. His drug of choice has been cocaine for the past 30 years. We did secure him placement, and they do have a bed space waiting for him at the program called the Benjamin Group Peer-to-Peer Housing Consultants. It's over in DeKalb County. I did speak with the director, Angelo Benjamin. I was hoping he could join us today to share with the court a little bit more about what they do. It sounds very hands-on. It is a secure inpatient facility. And so I would ask the court, I would like to have a date for Mr. Phillips to be actually released to their care. So once I get that, I will share that with the court. Like I said, he was under the influence of a substance at the time of this. And so we just ask that you accept the state's recommendation.
All right.
He has been in 170 days, I think, Judge.
Right. So if we did the 6 months, I just want to time it right so that if you get a date, we don't hear back correctly from the sheriff's team. Well, that's an early release because it hasn't been 180 days. It's only 10 days. But if you're pretty sure we could push the transport date outside that, then I'll just include in the final disposition to be released pursuant to separate order.
I think that's, just given that next week there's a holiday looped in, I think that's probably safest.
Good. Well, why don't Ms. Ross can work with Mr. Benjamin and their team to let them know Mr. Phillips wouldn't be available until, if we add 10, we'll say July 8th would be the earliest he could be available. And then assuming they've got space for him, they'll make that happen. Okay. All right. Mr. Phillips, where did you get the debit cards you had on you in January at Legends Cafe?
I got a can at a gas station.
Okay. Do you have family still in the Atlanta area? Brothers, sisters, parents, kids, what do you have?
And two sisters and cousins.
Okay. Are they a source of support or they've got their own problems?
They support me, they get on home in jail.
Okay. Do you have questions about anything we've discussed?
Not really, I was just hoping I was. Yeah, cause they said they had a bed for me, so it's possible.
They do. Let me tell you you have kids?
Yes.
How many kids do you have? 15 kids? 17 kids. You have 17 kids. How old is the oldest kid?
My oldest one, he's 33.
And the youngest?
7.
You have a 7-year-old.
Yes.
Okay. How many moms in the mix?
Too many.
Too many. 17 is also too many. So you have two too manys. Too many kids, too many moms. You think maybe you're going to hang it up for a while and not have more kids?
Yes.
17 kids. I think that is a record for me. Interesting. Are they all in Atlanta?
Yes.
Okay. You're not in a great state to take care of them right now. If you brought that up because you want to be present in their lives and contribute to their lives, you obviously need to be sober and healthy as we can get you. I know you are ill and some of those things don't just go away, but you need to focus on recovery because Mr. Phillips, a Father Phillips in the lives of those 17 who is maybe taking their money to go buy his next fix, they don't want you around. That's not healthy for you. It's not good for them. So let's focus on you getting to a stable place. And I hear you wanting to get out right away. I will tell you, I also hear the idea that you just ought to be locked up for a long time because you've had more arrests than years. You got a bunch of convictions and going to jail doesn't seem to necessarily change the way you go about things. But life is complicated. And I know you are working through a number of challenges on the physical health side and the mental health side. So I'm gonna go with this one, but you need to understand that if you walk away from this program, that's going to be a reason for me to say probation doesn't work. And we'll get you some real good treatment courtesy of the Department of Corrections, okay? And you're too old to be down there, but you're going to decide that, not me. So I find there's a factual basis for your plea. You were using other people's debit cards on January 4th of this year at Legends Cafe. I also find that your plea is knowing and voluntary, meaning you've understood what we talked about and no one's forcing you to enter the plea. You agree with that? Yes, okay. Ms. Wood, do you authorize someone in my office to sign the indictment on your behalf and Mr. Phillips's?
Yes, Judge.
And Ms. Smith, someone can sign for you?
Yes, Judge.
All right, Mr. Phillips, I will sentence you on count. So the thefts are all 1 to 3. Is the fraud something that goes to 5? Or do I need to stack?
The fraud is also 1 to 3.
Okay, all right. So Mr. Phillips, your sentence on count 1 is 3 years to serve 6 months. Counts 2, get back to your indictment. Counts 2 through 6 are 2 years. They're probated and they all run consecutive to count 1. So they're concurrent with each other. I'll explain this in a minute, but consecutive to count 1. And then count 7 is 6 months to serve. That all adds up, if you shake it together, to 5 years to serve 6 months with 4.5 years on probation. You've done almost 6 months, so you will be released soon. Although I am going to indicate on your sentencing sheet that you are to be released via a separate order that I will issue. That's going to be a transport order that gets you to Benjamin House. I don't want you to, hey, I'll get myself there, and then who knows where you end up. So Ms. Wood and her team will be working with Mr. Benjamin, and when they confirm, yep, here's a day where a bed is ready that is on or after July 8th, I'll sign that order that here's when I need Mr. Phillips transported to Benjamin House. And I'll get them to transport you with as much medication as I can convince them. Hopefully the good people at Benjamin House are ready to re-up your prescriptions because you need to be taking those things. Special conditions of your probation. Number 1, you stay away from Legends Cafe. Number 2, you enter into and complete at least 6 months of, can you repeat? It was a long name. It wasn't just Benjamin. You made it go away?
No, I haven't, sorry. It is called the Benjamin Group Peer-to-Peer Housing Consultants.
All right, you complete at least 6 months programming with the Benjamin Group Peer-to-Peer Housing Consultants Program. It may be that it's longer than that, and I encourage you to stay there. But if after 2 months you say, I'm done with this, and you walk away, you violated your probation, we'll get back together. And I've already told you what Plan B is. B actually starts with C for corrections, and that's where we'll get you treatment. When you're done with the Benjamin House programming, you will have a drug and alcohol abuse evaluation. That's when you'll be more actively supervised by probation. And if that evaluator recommends any drug treatment, that will be an additional component of your probation. I will waive your probation supervision fees for the entire sentence. Ms. Smith, anything else from the state?
Nothing further, thank you.
Ms. Wood?
No, Judge, thank you.
Ms. Simpson, I know you need to engage with Mr. Phillips. It sounds like Benjamin House is in DeKalb, so that's where he'll be reporting. I just want to make sure he doesn't get sideways with probation if Benjamin House says, you can't leave, you're getting our programming here, and yet he also needs to report. So I don't know how we coordinate something like that.
He can contact the probation office. Once he finds out if he is able to, report. It sounds, I'm under the impression he's possibly gonna need to be transported to probation, given that.
Right, and it may be that Benjamin House has a way of doing that.
Yeah.
I hope this is not their first probationer.
But he can contact them, the probation office, and if there is if the situation is the same as it is at Salvation Army, he can just notify them and they should allow him to just report back home until that period.
Good, okay, all right.
Just to add, when I spoke to Mr. Benjamin, it doesn't sound like it's their first rodeo with probation. He was actually asking me to make sure it was a special condition so that it's more of an incentive to complete the program.
Good, okay. I didn't think it was. If Ms. Ross was working with this group, it probably, hopefully was something that had been around for a bit. Mr. Phillips, any questions about anything we've discussed? Okay. I hope, Mr. Phillips, as you approach, did you say you're turning 58 on July, whatever it is?
That's on my.
You'll turn 58. Okay, well, I hope your 58th year and beyond, you're able to live a little differently than you have for the first 58, okay? All right.
George,
Yes, ma'am.
we're ready on Alex Blue. When?
You got all the paperwork you need? Well, let's do it. I think we've had victims here for a while, so
Yes.
let's do that. Ms. Wood, we're gonna do Mr. Blue next.
You got it.
We got Araldo still.
It's 3. Yeah. Yes.
Araldo and we
Areas.
did Mr. Williams.
Number 9, Felix, is it?
Right, Darius Fields and Chad Johnson. The rest got bumped to. Okay, so 1, 2, 3 more after Blue.
Judge, it is gonna be non-negotiated on the, like sentencing portion of it.
Okay, the part that would be non-negotiated?
Yes.
Yeah, okay. Are you ready, Ms. Smith?
I am.
Okay, I need the case numbers.
Yes, Judge, for position 1, same case number -01.
Yep,
And then position 2, same case number -01.
excellent. So it really is a superseding indictment.
Correct.
All right, okay. We'll get on the record. We are handling 2 cases with Mr. Blue, who is here in court with Ms. Wood, his lawyer. Ms. Smith is representing the state. First case is 25 SC 007-931-01. Second case is 26 SC 000028-01. Mr. Blue, in a moment, Ms. Smith is going to put you under oath and then ask you questions about your rights, these cases, and other things that may come up. You need to answer her questions truthfully and completely. If during the conversation you have questions, you need to make sure you let Ms. Wood or me know that. I can't read your mind. So if we're saying something that confuses you or isn't going the way you thought it was going to go, will you let me know?
Yes, sir.
Okay, Ms. Smith?
Yes, Judge. Mr. Blue, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Ma'am, yes, ma'am.
Please state your true, correct, and legal name for the court.
Alex Demetrius Blue.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No,
Is there any medication that you would normally take that you haven't been given today?
no, ma'am.
How old are you and how far have you gone in school?
41, graduated 2002,
High school or college?
high school.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in these two indictments?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with her services?
Yes.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
So wait.
Mr. Blue, do you remember being arrested on these charges?
Yes, ma'am.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
We are not.
No, ma'am.
Mr. Blue, do you understand that this is a non-negotiated or a blind plea and that the state will recommend a sentence to the court?
Yes, ma'am.
Do you also understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence for each charge?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes, ma'am.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea today?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
You said employment?
Yes, so basically what I'm saying is you have some adverse or unfavorable consequences taking a plea, and one of those could be your ability to obtain employment because of the felony conviction.
They'll run your criminal history, and this will show up as a conviction. That's the point. And so some employers might say, we're not going to hire Mr. Blue because he's got these convictions. Others may say, it doesn't have anything to do with whether he can drive a forklift or operate a whatever it is you might want to do.
Yes, sir, I understand.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm? And that if you did, you could be charged with another felony offense?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied that your client understands that these are the rights that they'll be waiving by pleading guilty to these charges?
I am.
Mr. Blue, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, ma'am.
As to indictment number 26 SC 0000028, how do you plead to counts 1 through 7, ag assault, count 8, reckless conduct, Count 9, possession of a firearm or knife during the commission of or attempt to commit certain felonies. And count 10, possession of a firearm by a convicted felon.
Guilty.
As to indictment number 25 SC 007931, how do you plead to count 1, aggravated assault, count 2, possession of a firearm during the commission of a felony? I'm sorry, the indictment change. Count 1, aggravated assault, count 2, simple battery, count 3, possession of a firearm or knife during the commission of or attempt to commit certain felonies, and count 4, possession of a firearm by a convicted felon.
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a right to directly appeal from your guilty plea conviction? But if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes, ma'am.
Do you understand that that process must be completed within 30 days from today?
Yes, ma'am.
Also, do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
All right, thank you, Mr. Blue. Where's the key? All right, Your Honor, this case, the indictment ending in 7931 went to trial. The state would show and the facts would show that on October 28th, 2025, officers with the Atlanta Police Department was dispatched to the I-75 exit ramp and Cleveland Avenue, that's in Fulton County, in reference to a person shot. Upon arrival, officers were able to speak with Mr. DeMarcus Buford, who was being treated by paramedics for a gunshot graze wound to his arm. Mr. Buford advised that he was standing on the side of the exit ramp talking to his brother-in-law when he made a statement, "If y'all don't support, y'all gotta go," to a man in a black Jeep Compass. That person that was driving that car was later identified as the defendant in this case, Mr. Alex Blue. Mr. Blue rolled down his window and asked Mr. Buford what he said and to repeat what he said. Mr. Blue completed his turn off of the exit ramp. He parked his car and walked back to where Mr. Buford was and shot at him, grazing his arm. And then he ran up and punched Mr. Buford in the face. Mr. Blue then ran away. Officers began an investigation and was contacted by a Miss Oasis Jones, who stated that she was with Mr. Blue at the time of the shooting and had recorded it. Ms. Jones also stated that Mr. Blue's ID card and both the video and the ID card had been given to officers in this case. Also, the officers did get a chance to speak with the victim in this case and his brother-in-law who was there, who identified Mr. Blue as being the person who shot at him and grazed him in the arm. Because of that, warrants were taken out for Mr. Blue, and he was ultimately arrested for the charges we have in front of us. For the indictment ending in 0028.
Before you go to the next case, I'm confused. Why is Mr. Beaufort standing on the side of the road?
He was selling water or like snacks for a football team.
Okay, so it's a on-ramp or off-ramp where there's traffic, it's metered, and so he's there, would you want to buy something?
Correct.
Mr. Blue is there because he is trying to get on the freeway.
He's getting off of the freeway.
Off the freeway. Okay, so there's a light. So he's getting off the freeway.
Correct.
So they would have an interaction because Beaufort would be saying, do you want to buy a Gatorade or water or something like that?
Correct.
And somehow the nature of that interaction and the words Mr. Beaufort chose prompted Mr. Blue to then pull over, get out, and do what happened.
Correct.
Okay?
For the indictment ending in 0028, if this case were to proceed to trial, the facts would show that on November 27th, 2025, officers of the Atlanta Police Department was dispatched to 42 Lethea Street, that's Lethea Street, that's Atlanta, Georgia, also Fulton County, in reference to a person shot. When the officers got there, they spoke with Santasia Logan, who is the sister of she's a victim also in this case, but the person who was shot, she's the sister of that person. Ms. Logan spoke with the officers who told them that her sister, Antasia Lowe was in the home at the time of the shooting and that she had been shot. And she called the officers and EMS to get some help for her sister. During this investigations, the officers were able to find out that the victims in this case is 7 of them, their family, they had rented this Airbnb for Thanksgiving. Prior to the day of the shooting, they had a family game night. And multiple people of their family came. It was identified that everyone that was there was family except for Miss Oasis Jones. Miss Oasis Jones came to the family gathering with another member of the victim's family, Monte. So because she was the only one that was not family, obviously she stood out. They were there to around 3, 4 o'clock in the morning. The shooting happened around 7. So when they left,
They meaning Oasis Jones?
yes, Oasis Jones and Monte, when they left the home, the people that were still there were the listed victims in this case. Around 7:30 in the morning, a car came down the street, fired into the home multiple times. At that time, Ms. Lowe, she was coming out of the restroom where she was then shot 3 times in the stomach. The others in the house, most were asleep because it's 7:30 in the morning. However, when they heard Ms. Lowe scream and heard the shots, they came out of the room, came to the front and discovered that she had been shot. At first, they just, thought something was wrong, but thought she probably had hit a table or something like that. But after they actually was able to like lift up her shirt or see her injuries, they saw that she was shot and called the officers. The investigator in this case was assigned to the case, and she started looking through kind of what happened. Officers came to the scene, saw those bullet holes in the walls, also in the home, and the investigator was able to identify the person, Miss Oasis Jones, had been in a relationship or situationship with Mr. Blue in this case. It was discovered through the flock cameras that a black Jeep Compass, the same car as in the other indictment, was on the street, had entered the street right before the shooting, and was the only car who had left the street right after the shooting and right before the 911 call was made. That Jeep Compass is not registered to Mr. Blue. However, the officers got in contact with the person who does own the car, Mr. Cortez Muhammad, and he told the officers that the only person who had his car during that time was Alex Blue, and that he gave it to him the night prior to the shooting. The investigators identified the relationship between Ms. Jones and Mr. Blue in this case, and stated that Ms. Jones had in some type of way gave her location to Mr. Blue, and that's how he was able to identify where she was, and under the impression that she was still there with another person, with another man.
Oh, with Monte.
Correct.
Oh, but she had left.
Correct. So the officers identified the black Jeep Compass as the suspect vehicle in this case as being the one that did the drive-by shooting. Later that day, the officers spotted the car because at that point, the officers had put out a bolo for that Jeep Compass. Officers got behind the car. The person driving that car, who is the defendant in this case, led the officers on a high-speed chase. They eventually apprehended Mr. Blue. He was driving. They found an empty magazine on him and also his phone. They took that into property.
So no gun, but a magazine to a gun, empty.
Correct.
Okay.
So when Mr. Blue was arrested in this case, the investigator was then able to continue her investigation by speaking with Miss Oasis Jones, who wasn't the most cooperative, but what she got from her is she went to interview her to talk about, what happened if you were at the family game night. Initially, Miss Jones stated that she was not there. However, after the officer told her that she had evidence that she was there, she confessed to being there. She confessed to knowing Mr. Blue, and she also stated that they had talked since he's been in jail. The conversation was kind of limited, but the investigator then listened to the jail calls of Mr. Alex Blue, who had reached out to Miss Jones in this case. They were having conversations about the officer came to the house and asked where his clothes were, and then Mr. Blue asked Miss Jones to remove those clothes from the home, and Miss Jones stated that she gave them to a third party. The officer indicated in the police report that the only thing they had a conversation, when I say they, I mean the officer and Miss Oasis Jones, but they had a conversation about was where Mr. Blue's gun was. So in the report, she indicated that she believed those jail calls were talking about the firearm that she asked Miss Jones for. Also in that conversation, Mr. Blue asked for Miss Jones to erase his data in his phone. And that's exactly what Miss Jones did. She erased his iCloud and the data in it. So when they got his phone and they did a phone dump, it was nothing to find because most of it had been deleted. Not about Mr. Blue here, but Miss Jones did have warrants taken out on her for tampering with evidence and things of that sort. But back to this investigation, in this case, the officers because they weren't able to do the phone dump, they were able to send his records over to T-Mobile, who confirmed that his phone did ping off of a tower at 7:30, which was 2 minutes before the shooting in this case. Because of those the digital evidence that we have in the case that places Mr. Blue at the scene, and also that following up investigation with his relation to Ms. Jones, warrants were taken out from Mr. Blue in this case. There are 7 counts of ag assault. That's for every person that was in the home. Ms. Lowe was shot 3 times. However, the other people that were in the home, they were asleep. It's my understanding that Ms. McMichael, who is the aunt in this case, a bullet went over her head. And then there were also 2 minors who are not here. They're not here today, but they were asleep in the back room where a bullet did go through that wall. So it's kind of serious and dangerous for everybody.
Sure, Ms. Lowe got shot 3 times. I mean, if it hit her in a slightly different place, she could be dead. So it's very serious. How is Ms. Lowe doing?
Well, she's here today.
Oh, she'll be able to tell us how she's doing. Okay, good.
I did get a chance to speak with the victims in this case. There's a victim named Miss Weir. Her mom, she's not here. She's at work. But her mom is here, would like to make a statement for her on behalf. There's also another victim named Mr. Xavier Mitchell. I gave him the Zoom link, but he's not here in person. But who we do have here in person who would like to make a victim impact statement is Miss Gloria Michael, Miss Lowe, and Miss Logan.
Okay. Before we do that, I just want to fully understand Oasis Jones. So effectively girlfriend of Mr. Blue. May have been girlfriend of someone else as well, but girlfriend of Mr. Blue. And just a month before the shooting at the Airbnb was the shooting of Mr. Beauford. And in that situation, Ms. Jones sounded like she was super cooperative. She said, he did it, and here I filmed it. You can see him shooting this guy.
Yes.
Okay, I just want to make sure that was what you relayed about the Cleveland Avenue shooting.
That's
is that she was very cooperative and in effect helped make the case against Mr. Blue.
Yes.
But fast forward to the Thanksgiving situation, then she actually engaged in a cover-up on his behalf, deleting the phone and getting rid of clothes, whether clothes was gun or clothes. She's not talking.
That's correct.
Okay. All right.
Oh, to finish, sorry, Judge. So the state's recommendation in this case is for the defendant to serve 15 years in prison. There is a recidivist notice filed. The state intends to withdraw under A, but not C, asking for the defendant, if sentenced to those 15 years, to serve it day for day. And that is all from the state. Not including the victim impact.
Sure. Okay. And he's a convicted felon, which would be the evidence to support the 2 convicted firearm by convicted felon.
That's correct. I did provide some certified convictions to Ms. Wood in this case about those 2 previous convictions for firearm during. There is a mandatory minimum of 10 years to serve imprisonment when you have a previous firearm during a commission of a felony. And since Mr. Blue has 2 previous ones, that's kind of guiding the minimum of the recommendation from the state, which is the 10 years.
Got it.
But now we're asking for 15 years to serve.
So in the indictment ending in 028, count 9, which is the firearm during commission, that the way it's alleged and given Mr. Blue's criminal history, it's a 10-year mandatory minimum, is what you're saying? Okay. And the same for the parallel one in the Cleveland Avenue shooting.
That's correct. I intend to run them concurrent.
Okay. Got it. All right. I do want to hear from the victims. Before we do that, let's knock out the criminal history piece. What do we have for Mr. Blue, please?
2014 ag assault, 2010 possession of tools, commission of a crime, felony theft by taking conviction. 2009 burglary ag assault conviction. 2007 burglary conviction. 2007 possession of a controlled substance, permanent entering government property conviction. 2006 burglary conviction. 2004 possession of a knife or firearm conviction. Possession of a controlled substance, felony theft by receipt, possession of a firearm by convicted felon. 2003 criminal interference with government property, possession of a knife or firearm conviction.
Thank you, sir. All right. Why don't you let me know the order in which folks would like to be heard? Let me say this. It's important that you all are here and you have a right to be heard. You don't have to say anything at all. If this has become a complicated situation, The facts speak for themselves in this case, but I'm happy to hear from each of you. If you've prepared something and you'd like the advocate to read it on your behalf, that's okay as well. But if any of you would like to speak either about your experience or the person you're here to represent, I don't mean legally, but as a family member, then if you'd come on up, you're going to sit in the middle seat of the table right there where the deputy's standing. But if none of you wants to, that's also okay. However you want to do it, just let the advocate know. We'll make sure it is, and we'll make sure it's bent towards them. Good morning.
Good morning, Judge.
Can you let me know who you are, please?
My name is Gloria McMichael, and I'm the auntie of Santasia Logan and Anastasia Logan.
Two of the victims.
Yes.
Okay.
I am the matriarch of my little small family. It's just about 6 of us, and I have to take care of them. And we had fun that Friday night that Wednesday night, which was game night with family members. So the next morning, I was in the first bedroom that's really off the street. And I heard all this commotion, but I didn't know what was going on until I heard Anastasia hollering. And I thought she had fallen over a table that we had put up for Thanksgiving. But and when we jumped up and went in there, she was laying in the floor. And she said, "I've been shot." I said, "Girl, you ain't been shot. I've never seen anyone been shot before, nor have I ever seen any bullet cases." So then I looked at her stomach and it was swelling up and it was bleeding. So then her sister, she ran up there. I said, "Y'all call 911, call 911. She been shot." So then it didn't take long for the police and the ambulance to get there. So they came in and the police and the detectives, and the room I was in, the first bedroom, he told me I was lucky because the bullet came over my head because I was the only one in that bedroom. And then he was showing me the casings on the floor. And then when she came, the bathroom was between the bedroom I was in and the bedroom that my two little nephews was in. They were in the top bunk. And so the bullets hit her. She had 3 bullet wounds in her stomach. And then when we went in the next room, we were checking to make sure the boys were okay. And it was a bullet that had went over their head. They were in the top bunk. It was 2 of them, 1 4 and 1 10, they brothers. So then the other bedroom, Santasia and Sherrielle was in that bedroom. So when she got shot, then the police, they took her to the hospital. We didn't know how severe it was. So then the detectives told us we couldn't leave. So my other niece, her best friend and her sister, she went to the hospital and she told us that they were taking her into emergency surgery. So because I couldn't leave, I just called my pastor and he prayed with her. So when I did get a chance to go to the hospital to see her the next day, the doctor asked me, was I squeamish? I said, "No, I'm not squeamish." What? And he showed me where they had removed the bullets. They split her stomach open and she couldn't go home because her house had stairs, her bedroom stairs. So when they released her from the hospital, she had to come and live with me. And I had to take care of her for 3 weeks. I had to feed her, I had to bathe her. And it was so horrific because I never seen anybody shot before. And we were just there trying to have a good time. And now we can't remember even we didn't even get a chance to celebrate Thanksgiving. We had all that food there and I had cooked and we were gonna just have a good time, and we were gonna leave that Friday morning. But we couldn't even, right now, I can't even phantom Thanksgiving because every time I see her laying on that floor and laying in the bed at my house where we had to change her bandages and then she couldn't go to work. It was just so horrible for me because I'm the one that take care of everybody since I'm the matriarch of my little family. And Judge, I tell you, I have never been my mother is deceased, their mother, my sister is deceased, so it's just me trying to take care of everybody. But when I was trying to take care of them, I just had to keep on praying, asking God to give me the strength so I can help her because she is going through so much right now. She is still dreaming about this and having nightmares, and now we just can't really enjoy life like we so used to because our little family, they get together, they come over my house and I cook dinner because I have a daughter. And I told my daughter, I said, she couldn't be there because she was at work. I said, I'm so thankful because you could have been planning all our funerals, and she didn't know nothing about that. You could have been planning funerals for your little family. And I'm just so sad that somebody would do that, not knowing who in their house, and especially with the babies sitting there. Anything could have happened to them, and they are my heart. I pick them up from camp and school every day because I'm retired. And I do everything I can for my family, Judge. It's nothing. If I got $1, they got 99 cents.
Well, Ms. McMichael, you have done amazing work on behalf of your family, and you've been put through something no matriarch should be put through because of what happened last, we'll call it Thanksgiving. You didn't get that celebration. Fortunately, it wasn't a mourning of the loss of someone, but you've lost the ability to enjoy holidays like that. No one's going to want to get together at an Airbnb and have a game night because of the memories of what happened that night. And I'm very sorry for that. I'm grateful that you provided that strength for your family and helped them get through the healing. It's not over. It'll keep happening. Mostly, I hope the little ones, the 2 young men who were in those beds, they didn't really understand what happened and they're moving forward as little guys need to. And this isn't holding them back. But those of you who are grown and knew what went down, you don't forget. The scars are here. And then for one of you, the scars are very, very real and manifest. I'm sorry you had to go through that. And I appreciate you being here to give voice to the impact. It's not just the reading of the police report, but here are people who survived that ordeal. I do have a question for you, if that's okay.
Yes, sir.
Tell me what Ms. Jones, Oasis Jones, what's her connection to
I
your?
didn't know anything about that young lady. It was.
How did she end up in your house?
She came there with my little cousin, Monte Lee.
Okay, so Monte Lee is someone you knew.
Yeah, he was my cousin because it was all the cousins.
Got it. And he brought her.
He brought her.
Okay.
That was the first time I had ever laid eyes on that young lady.
But her reason for being there, she didn't crash the party. She was with Monte.
I was there with him as his guest.
Got it. And Monte is family for you.
Yes.
And he was invited and welcome. And so she was welcome enough as his guest.
Yeah, well, he wasn't welcome. He's not welcome anymore.
I'm not saying that, but
I understand. I'm just saying my feelings.
Okay, got it. Well, thank you for being here and continuing to be strong for your family.
Thank you, Judge.
You're welcome. It's now afternoon. Good afternoon. You are?
My name is Equal Young. I'm the mother of Shariel Ware,
Okay.
Anastasia, Logan, and Santasia, Logan. They're my god sisters, which is back there. So the victim who was shot,
Were you there that night?
I was not there. So let me tell you how I came into the picture. My daughter was there. We don't know Alex Blue. Never heard of him, never seen him, had no connection to him. On November 27th, 2025, it's a day that as a mother, I will never forget. As a sister, I will never forget. As an aunt, as a family member, I will never, ever forget. I'm at home asleep. I receive a phone call. My phone continues to ring. It's my daughter. I wake up and I see the phone and I'm thinking that she's in the house. So I said, why is she calling? I didn't answer the phone.
She was supposed to come home after the game
She
night,
was gonna come home after the game night, but they asked her to stay.
but you'd fallen asleep.
I was at the game night too. I had already returned
Got
home
it.
and went to sleep.
Okay.
So the victim that was shot, Anastasia Lowe, and my daughter, they were both supposed to go home after the game night.
Okay.
They were asked to spend the night and stay. Go ahead, it's late, stay. So when my daughter called the phone, I'm thinking that she's in the next room beside me. So I'm just like, why is she calling me? So I didn't answer the phone. The phone rang again, didn't answer it. So the phone rang again. So I hopped up and I hear screaming, Mom, wake up. Miss T's been shot. That's what we call her pet name. Miss T has been shot. So I'm confused. I'm like, what? She shot? Like, where are you? What's going on? They was just like, go to the hospital, get to Grady Hospital. We can't leave the scene or whatever. So I'm still confused of what's going on. So I just hop out the bed, put on my clothes, fly straight to Grady Hospital. I arrive at Grady Hospital. I probably got the call probably about 7:40 in the morning. I probably got to Grady Hospital for South Fulton, less than 15 minutes. I was flying, probably could have been pulled over.
I was gonna say, probably didn't get there legally, but you got
I
there.
did not, I wasn't legal, Judge. I wasn't legal. I got there, and as soon as I got there, went to the emergency side, and I said the name. They knew immediately. So they were like, they escorted me upstairs. So I'm asking, what's going on? Because even when I got off the phone with them, I still didn't know exactly what was going on. So they said, give me a minute. We can't tell you. We got to get somebody else. So she's in surgery. So I'm just like, she's in surgery? What's going on? She's in surgery. The nurse came, one of the nurses that was in surgery, I guess, got a break. She came to me. So I asked her what's going on. They was like, we got to do emergency surgery. We don't know how long the surgery is going to be. We can't tell you anything. So I said, okay, all you can do is wait. So this is probably, like I said, I got there right before 8. So probably from about 8 to about 3 p.m. that afternoon. I'm sitting at Grady Hospital on Thanksgiving Day. The others, they're still at the house. The police investigation and everything is going on. They're calling me, asking me what's going on. I can't give them any information because I don't have any information. I'm just sitting there. Don't know, if she's alive, if she's dead, what's going on. Finally, around 3 p.m., they came down and got me. They brought me up to her room. They had just brought her out of surgery to the point where I started to get real ignorant and was just like, I need to see her. They're calling me. I need to let them know what's going on, to the point where I was just like, wrap her up. I don't care if she's not cleaned up. I need to see her. Went into the room, and of course, she's laying there in the bed. Couldn't break down because didn't want to cry, in front of her, because she didn't know what was going on. Because she was sedated and everything that day, we weren't able to wasn't nothing able to happen. So I left and I went ahead and contacted others to let them know what was going on. But as I sit here today, Judge, I sit here and I'm angry. I'm angry and I'm disappointed and I'm mad at not only at this man, but I'm mad at the criminal justice system. The offer of 15 years to serve is a slap in our face. It's an insult to us, Judge, that this man can have no disregard for people's lives and shoot up a residence of somebody that he doesn't know. Then to be brought here and to hear that this is not the first time that you have no disregards for lives. You've had this on a consistent basis. I'm disgusted at the fact that the ADA will reach out to us and present an offer of 15 years. While I understand that they have a job to do, like my aunt said, my daughter could have been dead, my sister could have been dead, they could have been, none of them would have been sitting here today. You understand? So 15 years, that's not enough for me. That's not enough for somebody's life that could have been taken away. It's only by the grace of God that she's still here. I went up to the hospital. I see her wounds. She has to get up every day and look at the scars on her body. I'm in the hospital. She can't move. I have to give her something to drink and hold the cup for her to sip. And you tell me 15 years is enough? 15 years is enough for two little boys that may not have been here? No, no, Judge. Like I said too, I have forgiveness in my heart, but at the same time, you must deal with the laws of the land. And Judge, 15 years isn't justice. And I just wanted to let y'all know that on behalf of not just myself and what I've gone through because of this, but my sister, my daughter, my aunt, my two nephews, and my niece. That's all I have to say.
I appreciate you sharing that. Good afternoon.
Good afternoon.
You are?
Santasia Logan.
Hey, nice to meet you.
Nice to meet you as well, Judge. I'm the 911 caller, also the little sister of the victim, Anastasia Lowe. Originally, I wasn't gonna come up here because everybody already said their piece. But I came to say I was angry, I was upset, but holding on to anger and harbor, it does no good for me and my spirit. And I am a very multifaceted person, so I see both sides to everything. And yes, he has a long rep sheet, and yes, he has extensive things that he has done, but I feel like everybody gets to a certain place for some reason. I say that personally because I do not have a parent. I don't have a mother or a father. All I have is my sister, and we're 15 years apart. So if she would have not made it on that day, I would have been crushed, and that would have deterred my entire life and how I went about everything. And not saying that I personally know that he has been through things that have condemned him to do the things that he has done, but I understand that in life, certain things will happen and will counteract the way you move or the way you should move in this life. So with that, I release all anger, any bad intention I felt prior to today. That was my purpose of coming up here, to release that off my heart. And to also say, like, I feel like people should take 5 minutes. Yes, we can be angry. Yes, we can be frustrated. But if you just take 5 minutes to think about where not taking 5 minutes could get you at, it'll make a big difference in everything. And not saying I'm a perfect citizen in no way, shape, form, or fashion, but I feel like sometimes just keep telling somebody, oh, you did this, oh, you did that. We know what we do. We're very aware. We have a brain that works.
And sometimes you just need somebody to forgive you and tell you, okay, I get it. And you can forgive yourself. Because yes, somebody else can forgive you, but as people, we have to learn to forgive ourselves. And somebody can forgive you just like I'm forgiving him. It doesn't mean he forgive himself. So he still has to hold on to that. He still has to process that. He still has to live his day-to-day life with that. Whether that's 15 years, 20 years, 30 years, behind bars, not behind bars, he still has to come to terms with it. So I came up here to say, thank you for everything you guys have done. You also, when it came to my sister and getting her the justice that she would like and what she would need. Now she will be up there next, and it may be a whole totally different story.
Great.
But I did want to come up here to say that.
Thank you. I appreciate you sharing that. And I think more of us need to adopt your take five principle. We'd have fewer cases here if people did that. Unfortunately, they don't always.
I have a brother that taught me that.
Okay, well, good. Thank you, ma'am.
Thank you. Can I have a piece of candy, please?
Only a crackle. Good afternoon.
Good afternoon. Your Honor, my name is Anastasia Lowe, and I'm submitting this statement to explain the impact of me being shot 3 times in my stomach on November the 27th, 2025. The impact it has had on my life. That day have changed my life forever. Being shot 3 times in my stomach was a traumatic and terrifying experience that I never wish on anyone. In the moments after the shooting, I feared that I was going to die. The physical pain was overwhelming, and the emotional trauma began immediately. The injuries I suffered required emergency medical treatment. I was rushed into surgery and was in surgery for 7 hours. I endured significant pain. My intestines was repaired in 3 places. The hospitalization of me being in ICU, the medical procedure, and ongoing medical care. Simple activities that many people take for granted became difficult or impossible for me during my recovery. I came home walking with a walker. Even now, I continue to deal with the physical effects of my injuries, including pain, discomfort, limitations on my activities, and concerns about my long-term health. The emotional impact has been just as severe as the physical injuries. Since the shooting, I have experienced fear, anxiety, stress, depression, and emotional distress. I often have nightmares. And think about what happened and how I came close to losing my life. My sense of safety and security has been deeply affected. Places, sounds, or situations that remind me of the incident can trigger feelings of fear and helplessness. This crime has also affected my relationships with family and friends. My loved ones suffer alongside me as they worried about whether I would survive and supported me through my recovery. The emotional burden placed on them has been significant. In addition, the shooting has created financial hardships, medical expenses, lost income, and other costs associated with my recovery have placed a substantial burden on me. The financial consequences of this crime continue to affect my life. What was taken from me cannot be measured only by medical records or financial losses. The shooting changed how I view the world. It disrupted my sense of peace, my physical well-being, and my ability to live my life without fear. While I'm grateful to have survived, survival itself has come with challenges that I continue to face every day. I ask, wait a minute. I asked the court to consider the seriousness of the term. I asked the court to consider the seriousness of the harm that was caused and the lasting impact this crime has had on me physically, emotionally, and financially. No sentence can undo what happened, but I hope the court will recognize the profound effect this crime have had on my life. Thank you for sharing my experience. I respectfully. That's it.
Thank you for sharing your experience, Ms. Lowe. You are a survivor, and it's very impressive that you are here today and have been able to relay to me what this has caused you. I've heard from family members, the impact it's had on them, the ripple effect through the family, but of course it's most profound on you. I'm grateful you are here. That's the best news of all.
Yes.
But it is always a reminder to hear from a victim that the case isn't over because we're taking a plea, that you will carry with you forever the physical scars and the impact that the shooting had on your ability to enjoy your life. And that's a forever thing, and that's unfortunate. But I appreciate you sharing that, and I wish you the best as you and your family move forward.
Thank you, Judge.
You're welcome. Ms. Smith, anything else? Okay. Ms. Wood.
Thank you, Judge. I too am grateful that she's here with us. You and I both know this could have been a very different outcome. And so I am grateful that she's here. Mr. Blue is here accepting responsibility. Judge, I want the family to know that the delay is not entirely Ms. Smith's fault or my fault. It's
When you say delay, I'm not,
I think they may, or I don't want to speak for them, but sometimes people think that it takes a long time for a case to reach resolution.
oh, this case is moving very, very quickly.
Yes.
Everyone should know, we typically resolve cases this serious in about a year because of the many moving parts. And your tragedy happened 7 months ago. So it doesn't seem fast. I mean, the good news is it's putting distance between the original trauma and today. But I wasn't perceiving a sense of delay. And I'm happy to echo that this is moving quickly and appropriately so. but well, you have cases where the bullet hit somewhere different, and so now it's a murder and not we have a survivor, and that can take a couple years to get in front of a jury.
Yes, Judge. And so part of so he is accepting responsibility. It was on for final plea just a couple of weeks ago. Ms. Smith actually had the agencies, there was a delay in getting reports to us. And so I did just want to share that with the court. That
Sure.
He has been.
Ballistics or what kind of reports?
So there was.
On everything?
Yes.
Okay. I'm just wondering what GBI did in this case. There'd be the obviously medical records, but those wouldn't be a source of delay.
So there's a third case, the fleeing, it's unindicted. It is related to this case.
Okay.
And there was Fulton County agency involved as well as APD. And
Okay.
There was a disconnect there.
Understood. And there was brief mention that it was a high-speed chase before they caught him. So that has yielded another set of charges. We're not dealing with those today. Will it be an MPGJ or TBD?
Not sure. I'm
Okay.
gonna communicate with the pre-indictment attorney, Judge.
Okay.
But as I said, Mr. Blue is here. He's accepting responsibility, Judge. He's 41 years old. He's a high school graduate. He does have family support. He is from Atlanta. He has 5 children. He was working at Russell Landscaping prior to these incidents. Judge, he's been in custody 210 days. My request that I mentioned earlier that we were disagreeing on, the state's asking for 15 to serve. We're asking for 15 to serve 10. That is no cakewalk by any stretch. I've seen people get probation for murder cases in this courtroom. So I just want to let everyone know that he's accepting responsibility. We're grateful that she's alive, and we would ask the court to consider 15 serve 10 with that 5 probated.
Okay. You may have mentioned this, Ms. Smith, and I'm just not remembering. Did your office have any success connecting with Mr. Buford? Okay. So we don't have a perspective from him on how he's doing. I understand it was a graze wound, so it wasn't nearly as serious as what happened to Ms. Lowe, but he was shot at and hit.
Correct. I did speak with the brother-in-law who was there, he gave a statement to the officers. The defendant in this case only had social media, so we tried to reach out and get in contact with him.
Through his Instagram?
So we only had called the brother-in-law.
Okay. All right. Appreciate it. Mr. Blue, anything you want to say?
Forgive me for my part from everything, sir, but this accepting responsibility of what's going on right now. I'm sorry for any harm or any damage I had to cause anybody.
Okay.
I will as I know I got kids, I overly understand. Got small kids. So I understand everything that then came up here and said. I can't do accept the fate will come to me right now.
All right. Well, Mr. Blue, I find there's a factual basis for your plea in both cases. Rather remarkable series of events. Illegal for you to have a gun. You knew that. And on October 28th of last year, you get angry because of words, you pull out a gun and shoot someone. You get away, and instead of thinking, I have some anger issues and I probably shouldn't be arming myself, less than a month later, you lit up that house in a way where we are fortunate that Ms. Lowe is the only victim. We are, of course, fortunate that Ms. Lowe is alive and can be here to tell us how she's doing. But the words of Ms. Young and Ms. McMichael ring in my head that there were kids, your kids' age, lying in that bed, and there's no controlling where these bullets go. And so you're upset that Ms. Jones is with someone else, and you take it out on the rest of the world. That's scary. It's not just criminal, but it's scary. And we talk about sentences being deterrents and this and that. Sentences sometimes are what we call incapacitations, because someone just needs to not be out in circulation, because when he gets mad, his approach to things isn't to turn the other cheek or to yell or maybe even to shove, but it's to shoot. And I think everyone here has a reason to be scared of who you are and what you do when you get angry and you've got a gun on you. It is remarkable that the sum total of the physical damage, I'm not talking about the emotional damage, but the sum total of the physical damage is what happened to Ms. Lowe. It could have been so different in both instances that were, to repeat myself, just a month apart. I also find that your plea is knowing and voluntary. I will accept them both. Ms. Wood, do you authorize someone in my office to sign the indictments, the superseding indictments on your behalf and Mr. Blue's behalf?
Yes, Judge.
Ms. Smith, someone can sign for you? All right. Mr. Blue, in 25 SC 007-931-01, that's your Cleveland Avenue shooting. Your sentence is... So does count 3, the possession of a firearm, I understand it's the longer sentence, but it is also one of these, it has to run consecutive?
I don't think it.
Or it doesn't have to run consecutive?
It just can't be suspended.
Okay. Let me make sure. The last thing I want to do is impose an illegal sentence on Mr. Blue. So let me look at that. So this is a second or subsequent conviction. That's why it's the 10 years. Okay, got it. Okay. Your sentence as to count 1 is 10 years to serve. Count 2 is 12 months to serve. Count 3 is 10 years to serve. And count 4 is 5 years to serve consecutive. So for overall, in the case ending in 931-01, it's 15 years to serve. You are being sentenced pursuant to OCGA 17-10-7C. In your other case, 26 SC 000-028-01, this would be the Thanksgiving shooting. Your sentence is as follows. For count 1, this is the shooting of Ms. Lowe. The sentence is 15 years to serve. Counts 2 through 7 are 10 years to serve. Count 8 is 12 months to serve. Count 9 is 10 years to serve. Those all run concurrently with each other. Count 10 is 5, nope, I got that. Count 10 is 5 years to serve, and that's consecutive to count 1. So that's a total of 20 years to serve in the case ending in 028-01. You're also sentenced pursuant to 17-10-7C. Those two sentences run concurrently with each other, and you get credit for the time that you have already served. Ms. Smith, anything else on behalf of the state? Ms. Wood?
No, Judge, thank you.
All right, thank you.
Are we taking a break by chance?
We should after this plea, but let's make a plan before we take the break.
Yep, okay.
Go for it. So we need to, Ms. Wood, we need to do Araldo?
Yes,
Okay, complicated plea, not complicated plea.
it shouldn't be complicated, but I need to speak here.
Okay. And then Fields, Ms. Rios?
Both my pleas are uncomplicated.
Okay, Fields and Johnson. And Ms. Smith, they're all with you? Okay. Hey. Yeah, we're gonna take a little break now. I don't want to do a full-blown lunch break now because we could finish the rest of the pleas and be done for the day. So how much time do you need? I agree. He's in a bad space right now, 20 years to serve. So on that clock, let's try to be back at 12:40. Ms. Wood, if we're back at 12:40, does that give you enough time?
Yes.
I'm not trying to rush. If we could knock out those pleas, we could be done for the day. Okay. 10 minutes. But then you get the rest of the day out after the last three pleas.
Thank you.
You bet. Thank you. That's a good call.
Coming back. Miss Smith. I'm sorry. He said, give us a 10-minute. Back and talk to that man.
What's up?
So I can go back and talk to them.
When they came out, I tried what I did. They apologized. I see that you did, but okay, I need for their mistakes.
Yeah.
Yeah, of course, they. I did choose a part that. Now, you guys are facing over here. On some dead end, I don't know what you're doing.
Yeah, I don't know, she's trying to get some answers, what's the problem, but don't really get, there's a lot of stuff on Monday, so she might not get that day, but, so I mean, I know.
They I'm end up going to jail.
Well, we don't want that to happen, so let's move.
This one, trying to.
Yeah, but we're trying to stop that from happening, so let me see what answers she get. She'll talk to us.
It's some kind of, it's me being excused from them for being on regular probation due to for feeling this.
Yeah.
It like, I don't,
Yeah.
it ordered me if I fail a drug test, it said I'm being placed on background, you know what I'm saying? Like,
Yeah.
it's something to fulfill.
Yeah, I'm gonna talk to her when she comes out. We'll be right back.
15 to serve or 20 to serve. It was 15. Oh, yeah, 20 to serve. To the way he like, cause I was
Wasn't that much on it?
well, and do what?
Right.
It's bad stuff.
No.
It just.
Understand. Oh. Oh.
We need to shuffle, and I'm like, I haven't even eaten this.
Every time I don't see Gordon here.
Oh, I know.
Pissed.
I'm like, the day is ruined.
Yeah.
The day is absolutely ruined.
And sometimes I stop doing this because I know he'd be getting annoyed. Sometimes I'd be like, where are you? He'd be like,
Where is he then?
I don't know, probably on vacation. Probably in Florida.
Do you have any bond, please, that you can do?
Everyone's in custody. Both these two people in custody.
Okay.
No, and hopefully these are quick. The day's moving a little faster than I thought it would, but mostly because you don't have all the pleas that I thought were gonna be at the calendar.
Right. Mhm.
How many do you have left?
Just this lady.
Okay. And you said hers is simple?
Mm-hmm. No, I just need to talk to her about the release date and make sure she understands.
Do you have recidivist too?
Sorry.
So day for day 20. Yeah, I mean, it was bad. So I don't see the purpose of withdrawing, but
Right.
Sophia's so funny coming in here.
What's she doing?
So she just tried to like still wear Leah down to do
No way.
Yeah. She was like, yeah, I guess she had some other business here. She was like, oh, let me see if she's a date. She said when she came in, Leah's put her head down.
What's the offer on that one currently?
I think 4 years.
Oh. Thank you.
Hey, why are you looking at me like that?
Who's the little person that you wanna add?
Deshaun Price.
No, that's not the little person. That's 3 cases. That's not the one you said earlier this morning.
That's what I was talking about. Because he's technically he's a little person, like physically. But he has 3 cases, but they're all like the same thing for around this. They're the same type of case. It won't take any longer.
We have too much on there.
But he has to be on there.
Why?
Because Judge is the one who's familiar with the Next Level Boys Academy. And it's gonna be too much to like try to get LB to understand. I told, didn't you see what I wrote about him losing everybody? And it's a nonviolent charge.
Is Miss Smith ready on it?
Yes, Miss Smith, you radio Deshaun Price.
No.
No, she was, no, this was one that was good.
We talked about it. I haven't offered it. It'll be a non-negotiated.
Well, my problem is we have a lot coming in on Monday.
I know.
We have a lot. We don't have the whole day. That's what, you don't see the rest of his calendar. So he has till maybe 1:30 or 2, and then he starts with civil stuff. So I don't have any room to bring anyone.
And we got that in the calendar.
Hmm?
And we got a calendar at 11 too. I don't know where we're starting it.
And then we have people, we have a show cost coming in. I don't even know that you're even involved in it. The show cost hearing come in, and then we have, that's on Dickens.
Oh.
Carrie or whatever her name
I've
is.
been in the email, but it's not my case at all.
Okay, her, she's
It's
coming in.
Gross revocation.
Right. And then we have, the woman in the wheelchair possibly coming in, Kayla Brown. So, I mean,
It's not, I mean,
So then we have the three people coming in from, it's either two or three that we didn't get to today that's coming back on
That's
Monday.
correct.
So. Oh, look at her. What kind of cake do you like? I meant to ask.
I like lots of cakes. I like chocolate, I like lemon, I like carrot cake.
Do you have any allergy concerns?
No, I have no allergies. Well,
So I was gonna ask her.
do you think even though he's going to family court, he could still hear to shot price?
So I went over.
Cannot hear any other cases. Once it's fine, once it's fine. Let me look at the schedule.
Okay.
Let me have the judge look at the schedule. Oh, can you look at Monday's schedule for me? And yeah, I'm gonna access this. Without negotiating.
But if Okoro goes away, that'll open up
It opened up to
other
bring
things,
the other people back, plus what you have on.
plus Kayla Brown and,
Yes. So I
Okay.
just want you to look at
Okay.
the same, like, who's Kayla Brown?
Why do I know that?
if you're here on Monday, you'll find out.
I don't know, I'm steering clear after I've heard everyone say the miserable day. I'd be hiding out.
Yes.
Oh, no, I think we have Robert Aaron.
Again, all right.
That's, you know, they fired Jerry Winbell. She's with the Capital Defender's Office.
Because I heard Christian Lamar left
Right.
and then so do
Well,
they have,
then we couldn't, it was in holding pattern because you can't go forward without cookout.
right.
So we had a status and she came up to the bench and we took it all down and she gave them what happened, you know, that was, they're still trying to find somebody. And then the big heavyweights came in
Hmm,
these people came in and her, you know,
yeah.
and told her she was third, they fired her out and said that she was made the judge, yet they don't even have a transcript yet. Well, she did.
That's weird.
It was really weird. So they were out, they out to get her for something, so that they changed the management. Yeah.
She's about to come out here. Well, I don't know which order he's
Oh,
going,
they
but yeah,
said
she
he
will
will
come out
off
here.
him. And he's been living for all these years.
That's not fair to him.
Right.
Wow.
It's so bad. I felt so
No,
bad.
it's too bad.
She was like, hold on. Years.
Oh, I think it's Sophia.
Yeah.
Oh, where's she
Why did you
go?
very passionate?
It's fine, I'm just move it.
Okay. She went in the back.
Oh.
All right, let's get rolling. Oops, we need Miss Smith. Well, we can be ready for her. Who are we gonna do first? There she is. Freshly hydrated. Who do you want to do? Let's break up Ms. Rios. So we'll do one of hers, then Ms. Wood, then another of hers. So
Johnson or Darius?
Darius Fields,
Oh.
Darius Fields, please.
Moving the cases though, that's all.
I know. Yeah, I wish it was my incoming docket, but that's all right. Happy to do the assist for
Family, when is the first day of July?
July 1.
A lot, didn't it?
I don't, July 1, there's nothing scheduled. July, we have a bench trial, day 2. Ben's getting us ready for it, right?
Who are the attorneys?
I don't know. I gotta look it up.
Divorce case?
Oh, yeah.
Oh, you're gonna. Litigations.
All right, Mr. Fields,
Yes, sir.
how you doing this afternoon?
All righty.
Good. I'm Judge McBurney, and we're gonna handle a plea in your case. Your case is 26 SC 001408. You're represented by Ms. Rios, who's here with us, and Ms. Smith is the prosecutor. Ms. Smith's gonna put you under oath, ask you questions about your case and your rights. Please answer all her questions, and please let me know if you have questions at any point. Will you do that?
Yes.
All right, Ms. Smith.
Thank you. Mr. Fields, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Darius Fields Bernard.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
Mr. Fields, your last name is not Fields?
It's Fields hyphen Bernard.
Okay, all right. You all right if we call you Mr. Fields for this?
Okay.
Okay.
Is there any medication that you would normally take that you haven't been given today?
No, ma'am.
How old are you and how far have you gone in school?
I'm 38 and I made it to 11th grade and got a GED.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes.
Do you need more time to discuss your case with your attorney?
No, ma'am.
And are you satisfied with her services?
Yes.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
Yes.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
Yes.
Mr. Fields, do you remember being arrested for these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
No.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend a sentence to the court of 5 years to serve 6 months with the balance probated?
Yes.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on this charge and run them consecutively?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes.
Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering a guilty plea today?
Yes, ma'am.
Are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yeah.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this guilty plea?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial. Do you understand that those are the rights you're waiving by entering this guilty plea?
Yes, I do.
Counsel, are you satisfied that your client understands that these are the rights they'll be waiving by entering this plea?
Yes.
Mr. Fields, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, ma'am.
As to indictment number 26 SC 001408, how do you plead to count 1, aggravated assault?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a direct right to appeal from your guilty plea conviction, but if you believe that there's some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal?
Yes.
Do you understand that that process must be completed within 30 days from today?
I do.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
I do.
Thank you, Mr. Fields. You're on it. Your Honor, if this case were to proceed to trial, the facts would show that on October 7th, 2025, officers of the Atlanta Police Department were dispatched to an assault call on the platform of the Art Center MARTA station. When the officers got there, they spoke with Roger Moses Jr., who advised the officers that he was hit in the mouth by an unidentified male that was on the platform at the same time as him. The victim in this case advised that his front tooth was knocked out and that his lip was swollen. The victim stated that he was aboard northbound cart when a male kept asking him, was he gay and what was he looking at? At this time, Mr. Moses, the victim in this case, told the defendant that he was not looking at him and that he was just trying to get to work. After this happened, the defendant was no longer on the scene. However, the officers were able to work with MARTA to look at the CCTV footage, and they were able to identify still pictures of the defendant in this case. They then put out a BOLO for the defendant where MARTA was able to identify him because he had previous troubles at the MARTA station with people where he was issued a 1-year suspension from the MARTA stations. At the time of this incident, he was still actively suspended and should not have been at the MARTA station at that point. After the defendant was identified as being the suspect in this case, he was arrested for the charges we have in front of us. Also, on that CCTV, they were able to see the defendant talking to the victim and also the assault. So that's why they were able to identify that the defendant in this case was the person who assaulted the victim. The defendant was eventually arrested for the charges we have in front of us. This also occurred in Fulton County. Regarding the negotiated plea between the state and defense, we've agreed to a 5-year to serve 6 months sentence with the balance probated. Special conditions of probation is for the defendant to complete an anger management course, for the defendant to stay away from the victim, even though it's my understanding that they are strangers. And also the state is asking for the defendant to stay away from all MARTA train stations. We do understand that this is a way that people get around. However, at the time this incident happened, the defendant was under an active suspension from MARTA, and to alleviate possible potential reoffenses at a MARTA station, we would just ask for the defendant to be kind of banned from any MARTA train station for the duration of the rest of his probation. And that is all from the state, Your Honor.
All right. Any contact with Mr. Moses?
No, Judge, no success with contacting me.
Okay, but your report is that his tooth was knocked out, not just that he got punched and so swollen lip or bloody lip, but he actually lost a tooth?
Yes.
Okay, all right. Criminal history for Mr. Fields.
65 seconds. Got 2019 Robert aggravated on peace officer conviction. 2011 unlawful restraint, that's a felony, you understand? Ag robbery conviction.
That's from some other state?
Correct.
Okay,
2011. 2009 unlawful possession of a weapon by a felony conviction. And 05 ag robbery conviction. This is out of Illinois.
okay, got it. All right, thank you. Ms. Rios.
Yes, Your Honor. Mr. Fields is 38 years old. He's originally from Chicago. He lived here for the last 3 years. Before he was incarcerated, he was working at Amazon in a staffing agency and as a day laborer. He has one child who's 15 years old that he has been providing financial support for. I'm asking that you accept the plea as negotiated. My only concern that Mr. Phillips has is that to stay away from all MARTA. That is his primary source of transportation, so that would be difficult. I understand the circumstances, but that was the only part that I told Ms. Smith that we weren't agreeing on for the negotiation. And I'm asking for his fees to be waived so he can get on his feet. He talked to me in the back when he wanted county time. I told him that you don't really have control over how that goes, but he wanted to see if it was possible for you to put something on the disposition that is supposed to be county time.
Okay. Mr. Fields, your child, male or female?
Female,
Is she in Chicago
yes,
with her mom?
yes.
Okay. What's your Atlanta or Fulton County connection?
I actually, I told you last time I came out here,
Yeah, remind me.
that I was dating someone.
Oh, that's right.
Relationship, brought me out here.
Okay. Okay. When you are released, do you plan on staying in Georgia or are you going back to Illinois?
After I get off probation, I'm trying to go back to Chicago.
Okay. Um, your your probation can be transferred to another state. If that can happen, would you move back to Chicago sooner?
Yes.
Okay. When you get out, do you have a place to stay in the metro area?
Yes.
What is that place? I don't need the address, but is it a friend's house or it's a relative or where will you stay?
It's a female companion.
A female companion. Okay. And what county does she live in?
Ford.
All right. Is the female companion a reason that would cause you to stay in Georgia, or you would still go back to Illinois as soon as your probation could be transferred?
I think I still will go back home.
Okay.
Because I was back and forth anyway, but.
Okay. All right. Do you have any questions about anything we discussed?
Not really, sir. I was just was wondering, like, would I be possible if I could be credited like 2 days for each day that I serve?
That's that whole county time thing. I don't decide that. The sheriff decides that. Okay. Have you had any disciplinary issues while you've been in there?
Sir, no troubles, no issues.
That's going to bode well then. That's part of what they'd probably look at. Well, Mr. Fields, I find there's a factual basis for your case and your plea, and that your plea is knowing, meaning you've understood what we talked about, and voluntary. No one's forcing you to enter this plea. Do you agree with that?
Yes.
Okay. Ms. Rios, can someone in my office sign the indictment for you and for Mr. Fields?
Yes, sir.
Ms. Smith, can someone sign for you?
Yes, Judge.
All right, Mr. Fields, I am going to sentence you to 5 years to serve 6 months with a balance on probation. You'll get credit for the time you've served. Special condition number 1 is that you stay away from, have no contact with Mr. Moses. He's a stranger to you. That should be pretty easy. Special condition number 2 is that within the first month of your release on probation, you need to apply for transfer of the supervision of your case to the state of Illinois. So you got to get that paperwork going that first month. Probation can tell you what they need, police report, this and that, things Ms. Rios can help you pull together. But I want you to start that process within the first month of your probation. At the end of 6 months of your probation, you're actually going to be required to stay out of Fulton County. So you got 6 months to figure out how to get back to Illinois. If you don't do that, you got to be not in Fulton County. So 7 months in, you got to be living somewhere else. Ideally, you'll be back in Chicago or wherever you need to be in Illinois. But if not, you got to be outside of Fulton County. That's going to address the whole MARTA thing. Between now and then, you need to stay away from the Arts Center MARTA station. And MARTA may already have some restriction on you. I'm not reducing or eliminating their restriction, but my focus on getting you away from MARTA is actually getting you back to Chicago, because you told me that's where you want to be. But if you go slowly with that and you get 6 months into probation, then you will need to get out of Fulton County. Another special condition is that you submit to a mental health evaluation. And if that medical professional recommends any treatment, whether it's therapy or medication or whatnot, that will become part of your probation. And I will waive your probation supervision fees for the first 6 months. So as long as you're here in Fulton County, before you have to get out of Fulton County, There are no supervision fees for probation. Anything else, Ms. Smith?
Nothing further, thank you.
Ms. Rios?
No, Your Honor, thank you.
Okay. Do you have that address where you'll be staying with the female companion? Do you know it?
Not by heart, but I got it in my sock.
He gave me an address.
Okay, I'm just asking because probation's gonna need it. They're gonna need to know where you're staying. I don't need you to get in your sock as long as Ms. Rios has it. Ms. Simpson's gonna come meet with you to give you reporting instructions. I don't think you're going into state custody. I think you will finish up here. I don't decide that, but I suspect you'll stay here. So you'll be released soon and you need to make sure you show up for probation when you're supposed to, okay?
Yes, sir.
All right. Ms. Wood, are you ready to go with Ms. Araldo?
Yes, sir.
Great.
I believe so.
I just submitted a proposed transfer order, Judge.
For Ms. Araldo?
Yes, I want to make sure that the medication, I'm hoping we can get it filed today so that it's enough time for the pharmacy to get her meds so that she can be released on Tuesday.
Yes,
Thank you.
sure.
Which is Ania's birthday and Miss Araldo's birthday.
Oh, it's my birthday?
Yeah. What is it, cancer?
Yeah. The sun. Come stand by me. Yes, ma'am. Thank you. Remember, if you have any questions, just stop me and talk about.
Tuesday.
Uh-huh. Okay. Yes, ma'am.
Yeah. Thank you.
You're welcome. Do you have any questions about?
Your birthday is Tuesday?
Yes, sir.
We're having a party for you on Tuesday. Look at that.
Thank you.
Oh, and you too. Well, that's how I learned is Ms. Wood said, hey, Ms. Araldo has the same birthday as Ms. Rios. I can't look up Ms. Rios, but I can look you up.
Thank you. Thank you.
Hmm?
Wow.
Oh, wow. Yay. I need that. I'm gonna need a lot of cake on Monday. All right, let's get on the record with Ms. Araldo's case. It's position 4, 26 SC 002 414. Good afternoon, Ms. Araldo. How are you doing?
Very good. Thank you.
Good. I am ready to go forward with your case. Ms. Wood tells me that you are ready to enter a plea. Is that correct?
Yes, sir.
Okay. Ms. Smith, who is seated here to my left, is going to swear you in a moment and then ask you some questions.
Okay.
Make sure you listen carefully to her questions and answer as best you can. But also let me know, or Ms. Wood, if you've got a question. If you can't hear what someone said or you're confused by what someone said, please let me know.
Thank you.
Okay? Ms. Smith.
Yes, thank you. Ms. Araldo, please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
First name Jody, Jodie. Last name Araldo, Iraldo as in David O.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, no, ma'am.
And is there any medication that you would normally take that you
I'm
have?
taking medication, yes.
Go ahead and answer. So wait till she
Okay,
or ask the question, then you can answer. Okay.
I'm sorry. It's my
That's
first
okay.
time.
You may know.
My first time, I'm nervous.
Okay, it's okay to be nervous and you may know the answer to the question before the question's done.
Okay.
But you gotta let, like just now, you gotta let the other person finish. The court reporter can only write down one voice at a time. So only one voice at a time. Wait till you hear that question mark from Ms. Smith. I'm gonna take over for a second. You take medication. Tell me for what you take medication.
I take chemical medication for seizures.
Seizures.
Yes.
Is that the only medication you take?
And I'll have a butyral inhaler for asthma.
So you take medication for asthma
Asthmatic?
and seizure.
Yes, miss.
Anything else?
That's it.
Okay. And when do you usually take that
I
medication?
take it twice a day. Well, while I'm incarcerated, they give it to me twice per day.
Morning and night?
Yeah, but I have an inhaler I carry with me
at all times.
Okay. Did you get your medication this morning?
Yes, I did.
Okay. Does that leave you drowsy or woozy or confused?
Not at all.
Thank you.
How old are you and how far have you gone in school?
Okay. I'm 63 years old. I'll be 64 on Tuesday. And I did high school.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes, ma'am. I understand.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes, ma'am.
Do you need more time to discuss your case with your attorney?
Not at all.
And are you satisfied with her services?
Very much so.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
I am.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
So waived.
Ms. Araldo, do you remember being arrested on these charges?
Yes, I do.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
We are not.
Do you understand that this is a negotiated plea of guilty, which means that the state will recommend to the court a sentence of 5 years to serve 8 months with the balance probated?
That's what we talked about in the back. Do you understand that? It's
No.
the same that we talked about in the back.
Okay, so what I'm saying.
What's your question?
I mean, what is the question?
So she's asking if you understand that what we talked about in the back, which is the 5 years probation served 8 months, but you get credit.
Okay, yeah. Yes, ma'am.
Okay.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those charges or sentences consecutively?
That means if Judge McBurney wanted to structure the sentence differently or give you something other than what we've agreed to, he has the ability to do that, okay?
Okay, yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you also understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing?
Yes.
Do you also understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea today?
Yes, ma'am.
Are you a United States citizen?
Yes, I am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from a trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Okay. Yes. Right.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am.
Are you asking to be treated as a first offender under the provisions of the First Offender Act?
Yes, I am.
Have you ever pleaded guilty or nolo contendere to, or ever been convicted of a felony in the state of Georgia or
No.
any other jurisdiction?
No, I have not.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No, I have not.
Has your lawyer explained the First Offender Act to you?
Yes, she has.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on first offender probation, your first offender status could be revoked, you could be adjudicated guilty, and you could be resentenced up to the maximum sentence for each charge in this indictment?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this guilty plea?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you,
Yes, ma'am.
the right to the assistance of counsel,
Okay.
the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Okay. Yes.
Counsel, are you satisfied that your client understands that these are the rights they'll be waiving by entering this guilty plea?
Yes.
Ms. Araldo, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea?
No, no one has.
As to indictment number 26 SC 002414, how do you plead to count 1, aggravated assault, and count 2, criminal damage to property in the second degree?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
Do you understand that you do not have a right to appeal directly from your guilty plea conviction? But if you believe that there's some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes, ma'am.
Do you understand that that process must be completed within 30 days from today?
What that mean?
So if we were gonna follow that, we would have to do it within 30 days from today, but we're not gonna do that, okay? Okay, so as long as you understand, it doesn't mean that we have to do that.
Yes, ma'am. Okay.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Again, I'm following that, but she's going over it because it's a constitutional right. So do you understand you have that right?
Yes.
Okay.
Thank you, Ms. Araldo. Your Honor, if this case were to proceed to trial, the facts would show that on October 6, 2025, officers with the East Point Police Department responded to 2864 Delow Drive in East Point, also Fulton County, in reference to a fight call. When the officers got there, they spoke with a witness named Alfred Townsend, who stated that he heard a loud argument occurring outside of his residence across the street from his home. Mr. Townsend stated that when he looked outside, he observed a female wearing a gray shirt, making a repeated stabbing motion toward the person she was arguing with an object in her hand. Although Mr. Townsend could not identify exactly what that object was, he said that the male repeatedly jumped back so he wouldn't be hit by whatever it was that the defendant in this case had. At that point, that's when he told the officers, that's when he called 911. The officers then made contact with the female suspect in this case, who was later identified as the defendant, and also the victim in this case, Marlon Hutchinson. The victim in this case, Mr. Hutchinson, he stated to the officers that the defendant is a friend of his who he's been assisting in allowing her to stay at the home for the past couple of months. He stated that they do not have a romantic relationship, but they've known each other for around 3 months. He stated that earlier in the day, the defendant and himself, they got into a verbal altercation revolving issues around the defendant getting a job or working with a temp service. According to the victim, the defendant then retrieved a red brick from behind the house and threw it at the 2878 Delow Drive home that the victim owns in this case, and intentionally threw a brick through the rear kitchen window of his residence, causing the window to shatter. The victim said after that, after damaging the residence, the defendant attempted to stab him outside using the end of a metal rat tail comb. Witnesses observed the observations that were taken by the witnesses corroborated the victim's account. And at this point, the defendant was arrested and taken into custody for the charges we have in front of us. I did get a chance to speak with the victim in this case, who kind of reiterated what happened in the police report. He said that they are friends. He does not want to see her in jail. He wants her to get help regarding alcohol or drugs so she could live a better life. I did give him the Zoom link. I talked to him this morning and he said that he's at Grady. He has a hospital. He has an appointment. And if he couldn't make it, he just wanted me to elaborate on the fact that he does not want her to be in jail, he's also not afraid of her or anything like that. So he's okay with the no violent contact provision for this case. Those are the facts and circumstances of the case we have in front of us. Regarding the recommendation in this case, we've agreed to 5 years to serve 8 months with the balance probated. Regarding the special conditions of probation, the state is asking for the defendant to stay away from the incident location, which is the home of Mr. Hutchinson, to have no violent contact with the victim in this case, for the defendant to complete an anger management course, also for the defendant to complete an alcohol and drug abuse evaluation with treatment if necessary. And I did speak with the defendant about restitution. He did say he would like restitution if it could be paid. So I would just put that, I would reserve restitution and then ask for a restitution hearing at the appropriate time. And that is all from the state, Your Honor.
All right. Criminal history.
6 cycles, no felony convictions for GCI.
Okay.
She did have an 014 drinks first, but they didn't have a
Okay, 6 cycles total though. Ms. Wood?
Thank you, Judge. Moments. All right, so Ms. Araldo is 64 years old. She's a high school graduate. Judge, she has 6 children. She's actually, before this arrest, she was working on getting disability for her epilepsy. From my understanding, they were in a relationship or a situationship, something else was going on there. Mr. Hutchinson actually does have a case where she is the victim. It's unindicted in our pre-indictment unit, so it just sounds like a toxic relationship, Judge. But she's here accepting responsibility. She has been accepted to work with PAD. They are able to get her next week if the plea goes through. So that is all we have. I would be asking for first offender treatment. I would be asking for a behavioral incentive date. And finally, I would be asking for probation fees to be waived for a period of time.
Okay. Ms. Araldo, any questions about what we've been talking about?
No, sir.
Anything you want to add?
Well, I just want to add that we were in a relationship for over 2 years.
Okay.
So, I mean, that was incorrect. And the only reason why I had a comb was because he was throwing my things in the street. And as I'm picking them up, he was coming at me. We talking about a 200-something pound man that lift weights. And when I turned around, he was coming at me. So I was swinging not to harm him. I didn't have to comb to harm him. It was trying to protect myself.
Okay. Well, it sounds like, as Ms. Wood described it, it was
It's toxic, yes.
Yeah, or at least tumultuous, if not toxic.
Yeah.
There must have been something that worked if you stayed together for 2 years.
Yeah.
But there were parts that didn't work so well. Do you have any need or desire to have contact with Mr. Hutchinson?
Not at all.
Okay. Then I'll probably make that one of the conditions. So Ms. Araldo, first I find there's a,
I'm sorry.
that's okay.
I'm saying that they said I could get a day too.
So she's asking a question about her credit for time served.
Sure.
She's been in 260 days. I left that part out. I
Right.
think that takes care of. the-
I'll get to that.
Yes.
I'll cover that.
So he's about to talk about it.
Yeah, let me finish, then ask her questions if I don't cover it, okay?
sorry.
That's okay. You haven't done this before, like you
Not
said.
at all.
So first, I find there's a factual basis for your plea. There are 2 sides to every story. One side is you were menacing with this comb and you threw a brick through a window. If the state could prove that up, a jury could find you guilty, so I find a factual basis. I also find that your plea is knowing, meaning you've understood what we talked about. And when you didn't, I watched you do it. You'd tug on Ms. Wood's sleeve and she'd explain to you and you'd say, okay, I get it now. Do you feel like you've understood things so far?
Sure.
And your plea is voluntary, meaning no one's making you do this. You've
Oh, not at
decided
all. Yeah,
it's what you want to do.
yes.
Okay. Then I'll accept your plea. Ms. Wood, do you authorize someone in my office to sign the indictment for you and for Ms. Araldo?
Yes, Judge.
Ms. Smith, can someone in my office sign for you?
Yes, Judge.
Excellent. Ms. Araldo, where are you going to stay when you get out?
Well, I'm going to the PAD program.
I'll help you find something.
Yes, they will give me stability and help me with my credentials and finance because I lost everything.
Okay, good. They will definitely do that. So stick close with them.
Yeah, I sure will.
You have 6 kids. Are any of them under 18?
No, everybody's grown.
Are they in the Atlanta area?
Only one.
Okay. Do you have a good relationship with that
No,
child?
not really. We got a distance one.
You did what?
We have a distance relationship, that one.
Got it.
That's why I'm trying to get my life back together, try to get him back in my life, right?
You want to be sentenced as a first offender. You qualify for that. That means that this technically is not a conviction. You'll have a sentence, but it's not a conviction. That helps with benefits. If you choose to work, other things you may want to do in life, you don't have to say, oh, but by the way, I'm a convicted felon.
Okay.
That's the good part. The risk is if there is, and I'm not saying there is, but if there is an alcohol issue or something that causes you sometimes to make bad choices, if you get arrested and in trouble while you're on first offender probation, if it's serious enough, the state can ask and the judge can revoke your first offender status and sentence you all over again.
Okay.
And your exposure is 25 years-ish. I'm not saying that's what would happen, but I'm telling you, if we're back together again in 9 months and you were swinging a baseball bat at someone, it's going to be a few years of prison, not only on the new charges, but resentencing you on the old ones. If you are committed to recovery and betterment and whatnot, first offender is a great thing. But you know best of all how likely it is you're gonna stay out of trouble over
Yes,
the
sir.
next.
I know you hear it 1,000 times, but you ain't gotta worry about it.
That would be 1,001.
Okay,
Okay, then I'll sentence you as a first offender.
thank you.
And I'm sentencing you on count one of the indictment to 5 years to serve 8 months. Count two is the same sentence, 5 years, serve 8 months. You'll get credit for the time you served, just a little more than 8 months. So you'll be on probation for 4 years and 4 months. But I'm setting a behavioral incentive date of June 26th of 2029, which is 3 years from now. If you have taken care of everything, not been a pain for probation, they can close it out early.
Okay.
Special conditions of your probation. These are things you must do. So you should listen to this. These are things you have to do. Number one, you stay away from that address on Delow Drive. It's not your home anymore. Number two, no contact with Mr. Hutchison. Don't write him, call him, Instagram him, however you guys communicate. Don't do that.
Okay.
Number three, you will submit to a drug and alcohol abuse evaluation. And that's just getting together with an expert who's going to talk to you about how you live your life. And if that person recommends any treatment, whether it's going to classes or this or that, that treatment will be part of your probation.
Okay.
You'll need to complete an anger management course. That you have to do within the first 4 months of probation. You need to get that evaluation within the first 2 months of probation. I will waive your probation supervision fees for the first 4 months of probation. That should give you time to get benefits in place if you're going to get benefits, or doing a little work on the side so that the supervision fees aren't too much of a burden. Ms. Smith, anything else in Ms. Araldo's case? Ms. Wood?
No, Your Honor, thank you.
Ms. Araldo, Ms. Simpson is with probation. She's holding that purple clipboard there.
Okay.
She's going to talk to you about when you need to report. You don't have an address right now.
No, I
Pat's
don't.
going to help you with that. So she's going to tell you, here's when you need to show up. You don't want to miss that appointment, because then they'll just send me a warrant and we're starting out in the wrong way.
Okay.
And until you have a stable address, you may need to be reporting much more frequently than you normally would. Once you have a place that is yours, then you don't have to report all that often.
Okay.
But if you,
You're gonna let me know.
she's gonna let you know.
Okay.
All right?
Okay.
Thank you, everyone.
And thank you. Thank everyone.
Oh, good
Thank
luck
you.
to you. Happy birthday.
Thank you. Thank you. Happy birthday. Thank y'all.
Mr. Johnson.
Seems. I know, I had a nice time. Please not to get cussed out.
That was almost perfect. Everybody took a piece of 2 feet.
Yeah, and they're pleading next week. Yeah, Rios is usually like 1 for 3. She's like, hey, we're bringing these over. And then 2 of them are like, what? No way. You're a bad lawyer. That always chaps me when they say that. Like, wait till you meet a bad lawyer. And you see. Hello, Mr. Johnson.
Morning.
It's afternoon. You've been napping?
Sorry.
It's all right. You ready to go?
Yes, sir.
You look sleepy.
I was sleepy. I'm ready to go.
Okay, good. All right, you ready, Ms. Smith? This is 26 SC 000299, State versus Chad Johnson. Chad Johnson is here with his lawyer, Ms. Rios. Ms. Smith is here for the state. Mr. Johnson, Ms. Smith is going to put you under oath, ask you about your case and your rights. Please answer all her questions. Also, please let Ms. Rios or me know if you've got questions. Will you do that?
Yes, sir.
Okay, let's get started.
Mr. Johnson, please raise your right hand.
Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can lower your hand. Please state your true, correct, and legal name for the court.
Chad Deontay Johnson.
Are you at this time taking or under the influence of any? You need him to spell it?
Yeah.
Okay.
DIONTE. Yes.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
And is there any medication that you would normally take that you haven't been given today?
Yeah. Do I say that?
Yeah, if that's
Yes.
approved.
Yes.
Okay.
So there's medication that they're not giving you at the jail?
I haven't took it today.
Oh, you didn't take it
They
today?
gave it to me every morning, but this morning I didn't get it.
Okay, and for what do you take that medication?
Oh, it's the Biktarvy. It's for HIV.
Okay, the fact that you didn't get it today, does that make it hard for you to understand what we're doing?
No.
No? Okay, and you have been getting it, it's just today, maybe because of transport, you did not get it.
Yeah.
Okay, I just want to make sure you're getting medication.
Yeah, I'm getting it.
Okay.
Mr. Johnson, how old are you and how far have you gone in school?
I'm 33. I go into the 11th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you may receive a jury trial.
Yes.
Have you had enough time to speak with your attorney about all of the facts and circumstances known to you regarding the charges in this indictment?
Yes.
Do you need more time to discuss your case with your attorney?
No.
And are you satisfied with her services?
Yes.
Counsel, are you satisfied that your client has a full understanding of this proceeding?
Yes.
Also, do you waive the formal reading of the indictment and any and all defects in the indictment for the purposes of this plea?
Yes.
Mr. Johnson, do you remember being arrested on these charges?
Yes.
The state is unaware of any outstanding warrants related to these charges. Are you or your attorney aware of any outstanding warrants?
Yes.
What else?
You've got warrants?
Wait, holds.
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 Sorry, not warrants. I'm sorry.
That's okay, they're very similar. You do, so you have places you gotta go when this is done. We'll get you there.
Mr. Johnson, do you understand that this is a negotiated plea of guilty, which means that the state will recommend a sentence to the court of 5 years to serve 5 months with the balance probated?
Yes.
Are you aware that the court does not have to accept that recommendation and that the court can sentence you to the maximum on each charge and can run those sentences consecutively?
Yes.
Do you understand that if you're placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you also understand that if you're charged with a crime in the future, that this plea may be used to enhance that sentencing, including on a federal case?
Yes.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on you entering this guilty plea?
Yes.
Are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be following a conviction from trial? For example, your guilty plea may affect your right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, or the ability to obtain employment.
Yes.
Do you also understand that by pleading guilty to a felony, you cannot use, receive, possess, transport, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering this guilty plea?
Yes.
Do you understand that by pleading guilty, you're giving up the following rights: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses called to testify against you, the right to the assistance of counsel, either hired by you or court appointed if you cannot afford an attorney, the right to the presumption of innocence, which means that the state must prove beyond a reasonable doubt that you're guilty of these charges, the right to testify on your own behalf or remain silent, the right to present other evidence of your own and call your own witnesses, and the right to appeal if convicted of these charges after a trial.
Yes.
Counsel, are you satisfied that your client understands that these are the rights they'll be waiving by entering this guilty plea?
Yes.
Mr. Johnson, has anyone forced, threatened, or promised you anything to get you to enter into this guilty plea today?
No.
As to indictment number 26 SC 000299, how do you plead to count 1, burglary in the 2nd degree, and count 2, willful obstruction of law enforcement officers?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand that you do not have a right to appeal directly from your guilty plea conviction? But if you believe that there is some type of error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal.
Yes,
Do you understand that process must be completed within 30 days from today?
yes,
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
yes.
Okay. Thank you, Mr. Johnson. Your Honor, if this case were to proceed to trial, the facts would show that on January 10th, 2026, officers responded to 200 Nerem, Nerem Street, Northwest Atlanta, Georgia, also in Fulton County, when the officers, and this is an apartment complex, the address that I gave. Upon arrival, the officers had a conversation with the leasing manager, Alyssa Horlback. First name is spelled Elissa. Last name is Horlback. Ms. Horlback advised the officers that a male suspect came into the apartment complex trying to gain access to the package room. She stated that the suspect was a light-skinned male with blue-colored dreadlocks, wearing a black t-shirt, orange shirts, and tights underneath. The suspect was accompanied by an unknown female. Ms. Horlback stated that the male approached the package room and attempted to retrieve a package. The suspect asked Brittany Lathan, who is an employee there at the apartment complex, to grant him room to the package room. At that time, Ms. Lathan stated that the suspect in the case, who was later identified as the defendant, told her that the manager would be coming to unlock the package room. She went to go confirm if this person was, or the defendant was, a resident of the apartment complex or if he should be able to gain access. However, she was told he should not. When Ms. Lathan returned to the package room, the defendant in this case was no longer present. She observed that the defendant was entering a white Nissan Pathfinder and that the female entered the vehicle shortly after, that unidentified female. The vehicle then left the area. No items were reported stolen at that time, but both Ms. Lathan and Ms. Horlback, the employees of the apartment complex, stated that they were certain that the male was the same individual who was seen in a prior theft incident. When other officers got to the scene and gathered more information on the suspect, they were also able to gather more information on that white Nissan that the defendant was seen getting into. They were able to do a bolo hit for that car. The officers was able to stop this car later in that day, and they observed a male matching the suspect description from the earlier burglary as the defendant in this case. When the officers approached the vehicle, they detained the defendant. During the detention, the defendant stated, he resisted and attempted to flee on foot. The defendant was apprehended and eventually arrested for the charges we have in front of us. At first, the defendant identified himself as someone else and stated he didn't want to give his information. However, he eventually gave his date of birth and name to the officers where they were able to identify him. Those are the facts and circumstances of the case. Regarding the negotiated plea between the state and defense, we've agreed to a sentence of 5 years to serve 5 months with the balance probated. The state is asking for the defendant to stay away from the incident location, to complete an anger management course, also to complete 30 hours of community service, and to be gainfully employed.
I think it was an anti-theft club, not anger management.
Did I say anger management?
You did.
I meant I meant anti-theft course, not anger management.
Understood.
My
That fits better.
apologies. Yeah.
Okay. All right. Criminal history information, please.
10 cycle, 2017, possession of a Schedule 2 conviction. That's all.
All right. Thank you. Ms. Rios.
Yes, Your Honor. Mr. Johnson is 32 years old. He does not have any children. He last worked 2 years ago as a server. He's been battling with drug addiction. I tried to go the route of drug court, but because he had a hold out of Alabama and another hold date, it was a little bit too far. It's not like it was just a cab having a hold, so they did not accept him. So I'm asking you to accept the plea as negotiated and waive fees. I think it's going to take a lot for him to get back on his feet to be able to work.
What holds are you aware of?
Alabama, and then is it Carrollton or is it
True County,
True.
LaGrange.
LaGrange?
Okay. Got it. What's waiting for you in Alabama?
I have probation violation.
Okay. All right. Anything you want to add, Mr. Johnson?
No.
Okay. Ms. Smith, just so I understand the fact pattern, Mr. Johnson supposedly said, hey, you should let me in the package room. And the person said, I'm not so sure. And he said, the manager said it was okay. She goes to check with the manager, and when they come back, he's gone. It's not that he broke into the package room. He tried to talk someone into letting him into the package room.
Yes.
Was he a known source of trouble there, or any reason why they would think that he was trying to take something that wasn't his?
Yes, Judge, they have prior incidents with the defendant of stealing packages from the package.
Okay, all right.
Who would like to say something?
Yes, and it wasn't me who asked to go in the package room. It was the girl who I was with, and I came around and I heard her, and I left out the back door.
Okay.
I heard her say that.
Okay, I just wondered why their antenna were up about you. And because this isn't quite, sometimes it's you're caught and you're reaching for the package, or you've got, not you personally, but someone is caught running with the package, or they get away with the package. But then when we find their car, what was in the package is in the car. Yours was, I call it an attempt. But you want to work it out and get on your way, and that's all fine and good. So I find there's a factual basis for your plea. Your plea is knowing, meaning you've understood what we talked about, voluntary. No one's forcing you to enter the plea. You agree with both those?
Yes.
Ms. Rios, someone in my office can sign the indictment for you and Mr. Johnson?
Yes, Your Honor.
And Ms. Smith, someone can sign for you?
Yes, Judge.
Great. Mr. Johnson, I am going to follow the negotiations here. Your sentence on both counts is it misdemeanor obstruction? Because he just ran. Okay. Your sentence on count 1 is 5 years to serve 5 months with the balance on probation. Count 2 is 5 months to serve. They'll run concurrently at the same time. You'll get credit for the time you've been in. So you should be on your way to your holds in the next few days. When you return to Georgia, you'll have some conditions of probation. 1 is stay away from that apartment complex. 2 is get your GED. You got close, 11th grade, so get your GED. 3 is complete 30 hours of community service. You'll need to do that within the first 4 months of probation. You'll need to enroll in the GED program within the first 4 months of probation. But probation doesn't start for you, for your purposes, until you're out. So it's not like you have to figure out how to do community service if you're stuck in Alabama dealing with whatever's going on there. Because we couldn't get you into one of our accountability courts, within the first 2 months of probation, you need to get a drug and alcohol abuse evaluation. And whatever that expert says you should do for treatment, go to AA meetings or this or that, that treatment will become part of your probation. Okay? Anything else, Ms. Smith?
Did he count the weekends as business days for extraditing?
Do they count the weekends as business days for extraditing?
I don't know. It's a good question. I'm not sure why you think the extradition clock should start now, or it's already run?
No, I didn't know like what time when does it start, and do they run on weekends? Sometimes they just count weekdays.
Yeah, I don't know how that works, but you also have the whole LaGrange thing, so maybe you go there. I don't know how they prioritize those. Okay, good luck.
Thank you.
You're welcome.
Ms. Rios, as advertised, those were easy, simple. Thank you.
Well, she said 1:30.
Yeah, yeah. And I talk too much, so that's why it takes long. Thank you, everyone. You moved through a lot of cases. They were cases that needed to move, especially Mr. Blue. We'll see everyone not tomorrow. Monday is going to be interesting.
What's on there other than what we have?
We're not going to be able to add price on Monday because the big thing on there I thought was going to go away, but it's back, is a 414 hearing in a case with Ms. Williams stateside, Mr. King, and it's other victims. And Mr. King has asked for a hearing rather than a proffer. And they are far away, so they are flying in here. So that's what we do first. We have a pro se guy who wants to be relieved of paying restitution because he thinks his victim got insurance.
Oh, you're putting that one else from Monday?
Mr. Cano.
Oh, that's not him. Had a similar issue, but I guess Ellerby will.
And then there's some walk-in with Judy Kuhn. We'll figure that out. Ms. Wood has a plea on Greer. In theory, Kayla Brown is coming in. We'll see.
I guess I don't really have anything on Monday. I might show up on the Zoom because Mr. Ricky Pierce is pro se, but I went to go see him. He said he's still pro se.
Ricky Damon Pierce?
Yes, he's on.
The murder case?
Yeah, he picked up another case in jail, but he's still, he's on.
That's a gift for Judge Ellerby.
Are you gonna move it?
Well, if he's on, I don't know that he's on, but
On, right?
okay, his murder will be something Judge Ellerby deals with.
Yes, he's on for the new case, but he still wants to be represented by himself for the new case, but
Good.
I will be on Zoom.
He is an American citizen. Or whatever it's called, a national citizen. That's his, it's not sovereign citizen, it's